Your Lordship, my wakalatnama and my competency is there. Your Lordship will see this is a client from Delhi. So I have to file my written statement. The notary is of 9th of July. Lordship, however, while at that time, because it was posted from Delhi, it was received in Calcutta in 14th. So the date was entered as 14th of July. Lordship, because of this discrepancy, I am unable to file my master summons and my written statement along with my master summons. I am for the defendant number 2.
What has happened? Notary is of
9th of July. Your Lordship, the client is in Delhi. He had affirmed it. He had signed the wakalatnama on 9th of July. Though notary is not required in a wakalatnama, but he had got it notarized on 9th of July. He posted it on 9th of July. We received here on 14th of July. Your Lordship, so while accepting the wakalatnama here, the advocate on record has endorsed it as 14th of July because that is the date when he had received it. Lordship, the department is not accepting it on the ground that there is a discrepancy in the notarized date and the filing date. So, Lordship, only leave to file the wakalatnama. The only hindrance being I am for the defendant number 2. Lordship, I am in the additional 30 days period. I have to file my written statement along with my master summons for acceptance of written statement. If your Lordship would grind.
Monday to be mentioned.
Grateful, Lordship.
My Lord, may I have the liberty of mentioning a matter, a suit, my Lord, upon notice to my other side. My Lord, this suit was due to appear next Monday. My Lord, the witness, my Lord, there's a bereavement in his family. And my Lord, he is, my Lord, not in a position to attend court. I was only praying, my Lord, if this matter can be, my Lord, taken up, my Lord, 2 weeks, my Lord, hence, my Lord.
When the matter is fixed?
29th, it is supposed to appear, my Lord. And he is an outstation witness, my Lord.
What is the time? What is the time?
Lordship, may I be
Call the matter.
Lordship, may
I be permitted to mention this matter?
Lordship, for the inclusion in your Lordship's list, Lordship, upon notice to the other side, it's an execution case, Lordship. The judgment debtor has paid only one installment. As per the last order, Lordship, he had promised that he would pay the entire decretal amount in 6 equal installments. But he has just paid one installment. After that, he has stopped paying the installments, your Lordship. Lordship, I'm praying that this matter, let it come under the heading examination of judgment debtor.
No, let first come as to be mentioned.
Grateful, your Lordship.
Lordship, I'm mentioning this application. There's a new application that has been filed, GA-COM 7, for inclusion in the list.
For what?
This application was filed for discovery of new documents, Lordship.
Who is for the other side?
We have already served the
for the?
I'm for the plaintiff, Lordship.
Usko bhi to be mentioned.
Lordship, I would take your leave to mention this matter, your Lordship. It was dated 22nd of July 2025, OCD 64. Lordship, I was led by Mr. Rotnanko Banerjee. I was for the decree holder. Lordship, our names have not been recorded.
You have given the names?
Yes, your Lordship. We had
Whom?
Your Lordship, we had given it here.
I apologize. I tried to say
matter is mentioned by the learned advocate appearing for the learned advocate for the plaintiff, and submitted the matter was taken up for hearing on 22nd of July 2025 for passing interim order, ad interim order. But in the order dated 22nd of July 2025, this court has only recorded the name of the senior advocate, though the other advocates have also appeared with the learned senior. Accordingly, she prays for recording the name of the other advocates who have appeared along with learned senior advocate before this court at the time of hearing of the application on 22nd July 2020. In view of the submission made by the counsel for the plaintiff, what are the name? Give the name.
Yes, Your Lordship.
Name of Sensation should be recorded in the order number as appearing advocates on behalf of the plaintiff. Okay?
My apologies.
The order may be incorporated with the order. Yes.
I tried to say 2 p.m. my lord.
You persons are coming with mentioning without knowing the date, without knowing the facts, without knowing any mentioning. You have given the 3 documents. You are not annexed the paper.
My lord, last order has not been uploaded.
Then, huh?
Last order has not been uploaded. On
not even uploaded.
No. So
which date order?
Therefore, I have mentioned that.
You give?
5th May.
Which date order?
5th May. 5th May. It is indicated in that list.
Which date order is not uploaded? Tell me.
My lord, 5th May. Last order which has been uploaded is 5th of May. 15th of May the matter was there. That order has not been uploaded.
Which 5th May order?
15th May. 5th May order has been uploaded.
Ah.
15th May order was not uploaded, my lord. Therefore, I have given that page.
15th May? How the 15th May order? 15th May, this court is not here. This court was not here. This court was in circuit at Jalpaiguri.
इसमें 29 July.
5th May क्या date है?
29 July.
हाँ.
29
At
2 p.m.
28 July. You are telling me 29 July. That's why I'm asking the document. You are telling that is uploaded. How you are telling?
Therefore, maybe after notice it perhaps was.
ठीक है, उसको मार्क कर दो. 29 जुलाई का है ना? 28 July. मार्क करके रखो उस दिन. Come on that day, I will fix another date on.
I'm grateful, madam.
In
My
presence of
apologies.
other party.
My apologies.
Yes.
Appearing for the defendant respondent, Lordship.
In the facts and circumstances mentioned above, this court finds that the defendant has raised tribal issue which can be decided only after the evidence of the parties and no summary judgment can be passed. GA is dismissed. Yes. No.
But initially, clause leave was granted under section 12A. Thereafter, that leave was revoked. Thereafter, 15 days time was given to comply with the provisions of 12A. We have complied with the provisions and we are before your lordship.
Why? It is before the master. There is no leave.
No, why?
Why it has come here? Okay, record. The plaintiff has filed the suit praying for decree for a sum of rupees 1,01,79,338 along with interest at the rate of 18% per annum. Full stop.
May I indicate one thing, lordship? Lordship, initially the suit was filed with court fees of 50,000 rupees. Thereafter, when the claim was rejected, again 50,000 was tendered for the purpose of filing the appeal. Now, my lord, my advocate
filing the
appeal, my lord. So 1 lakh rupees has been paid as court fees. My lord, thereafter, when it was drafted, my lord, this plaint, my lord, it was under the impression that since we have paid 1 lakh and that is the continuation of the same suit, my lord, that will carry. My lord, because of which it has been filed with deficit court fees, my lord. At the time of conference, my lord, I advised themselves to tender the entire court fees, my lord, because of the fact that the appeal was also dismissed. My lord, therefore, my lord, kindly grants me 7 days time, my lord, I shall tender the deficit court fees.
क्या बोला? After initiated pre-mediation process which ended as non-starter report. As the plaintiff has not prayed for any leave, accordingly, plaintiff is admitted subject to scrutiny by the department. Full stop. Counsel for the plaintiff submitted that the plaintiff is filed with the deficit court fee and undertake that he will file the deficit court fee within a period of 1 week.
But 2 weeks if
within a period of 2 weeks. In view of the above, the plaintiff is granted liberty to file the deficit court fee within a period of 2 weeks from date. Admitted subject to scrutiny.
We were supposed to enter into an agreement on 22nd. We had a meeting with the plaintiffs as well, my lord. They're not there, my lord, not today, my lord.
Let it go to the mediation.
But we have anyways entered. We have agreed to the term. There is only one point which remains, my lord, which we would further have a discussion on. My lord, may keep it 1 week hence, my lord.
So let it be go to the mediation. It may be settled. Where is the other party?
Not there, my lord.
Yes.
For the plaintiff, Lordship had directed the parties to come
Settled.
to a terms of settlement. In the suit, the defendant has lost its chance to file the written statement. So the suit will proceed ex parte. Due to that, my learned friends are now interested to take my dealership. I am told that they are in the midst of negotiations. Lordship passes.
So I am sending it to the mediation.
The draft. I am told that the draft is about.
Settle it.
Lordship, I am told that the draft is about to be finalized. It is
Received a revised draft
Yes,
yesterday evening, my lord. 1 week's time may be given, my lord.
Why you are not going to the mediation?
Lordship,
There's a
only the
Supreme Court
execution,
direction.
Lordship,
Supreme
only
Court
the execution is
direction
left.
there.
Execution of the draft. Lordship grants us a week's time. If it doesn't happen, Lordship.
As per
send
prayer
it for
made by the
mediation.
council with the parties, let the matter appear on 5th of August 20.
Great. Extremely good.
My lord, I am appearing for the defendant, my lord. May I file, my lord,
Your
Yes.
Lordship, Your Lordship, I am appearing for the petitioner. I am asking for an accommodation for 1 day. I am late by Mr.
You are appearing for whom?
Petitioner.
What you are filing, madam?
My lord, the affidavit in reply, my lord. This was an
Affidavit in reply of
my lord.
G8.
Yes, my lord.
G8.
Yes.
What is the G8?
My lord, GA8 is my application, my lord, for transferring the suit to non-commercial determination, my lord. According to us, my lord, this dispute is not a commercial.
It's not a commercial suit.
Yes, my lord. My lord, may kindly keeps, my lord, after
File, give the copy.
I have given
The copy has been served.
It is only.
How you are in court?
I was supposed to be here in court today.
You are telling that you will not be available.
It's the 25th, Malak.
20.
But I'm not available next week. I'm sorry, Malak.
Affidavit in reply. In connection with affidavit in reply filed by the defendant in connection with GA.com 8 of 2024. Be kept in the record. Counsel for the plaintiff prays for time. According case is adjourned. Let the matter appear on 18th August for hearing of GA 8 of 2024.
May it please your lordship, this is my application, and I'm appearing on behalf of the plaintiff in an undefended suit, where my main relief, Millard, is for recovery of possession together with consequential reliefs. Now, Millard, your lordship had passed an order on 25th February 2025, Millard, where your lordship had marked this matter as an undefended suit, had also, Millard, further given direction on the plaintiff to adduce evidence through affidavit and file the judge's brief of documents. Millard, we have already filed our affidavit of evidence. But Millard, in this course of time, we have discovered, Millard, that we have 6 bank statements of 3 individuals who are all plaintiffs. So, Millard, we will be having more than one plaintiff, one witness. And Millard, the 2 witnesses are above 65 years of age. So, Millard, this is my application for commission. Also, Millard, in this application, I am seeking for disclosure of some further documents, which are, Millard, the bank statements. Millard, bank statements were already filed along with the plaint. But now this is an undefended suit, Millard. So we advised our client that you kindly get it stamped and certified by the banker.
It was disclosed in the
yes, earlier disclosed.
So why you are filing this application?
Millard, because now I want to introduce, Millard, the same bank statements with certification from the bank.
For exhibiting?
For exhibiting. That is the only purpose. Now, Millard, if Lordship kindly sees, Millard, the original Millard, undefended suit, page 105, that is the order.
Yes.
And Millard, by this order, Millard, we have also filed our affidavit of evidence. At page 106, Millard, there was a direction upon us to file our affidavit evidence.
Yes.
Now, Millard will kindly see the original bank statements which we had filed, Millard. The original bank statements
Along with the plaint.
Along with the plaint, page 46 to 86. These are of 6 banks. These would only show that I have received rent from the tenant.
46.
That is Bata. Yes, Millard. 46 to 86. Your Lordship will can only
46 through 86 of J2 or plaint.
not of the I just indicate, Millard. It begins from page 46. Your Lordship will kindly see, Millard, the page number at the bottom.
It is
Yeah, this one.
in the plaint.
Yes.
Yes.
Millard, 46 to 86. Lordship will find
That
that
is
these are
account
bank
number
statements.
3140 of in
Yes.
the name of
Swastika
Swastika
Paul,
Paul.
Archana Paul. Millard, the Pauls are the plaintiffs.
Swastika Paul and Archana Paul.
Yes.
Yes.
And Millard, these are the bank statements.
46 to
86.
86. Only 80 is there.
Millard, 86. Actually, Millard, the page number in the bottom.
No, here in your plaint, I am on in the plaint.
Millard will kindly take the application.
Plaint containing only the
Yes, yes.
80 pages.
Millard, maybe the page numbers are. Kindly sees, Millard, the plaint is also annexed with
67. Yes, 46 to
86.
86.
Yes.
Yes.
Which is a part of the plaint. It matches with the plaint. The last page, which is shown as page 86, is page 64 of the plaint. Of the plaint separately. Archana Paul.
Yes, 64.
Yes. So, Millard, that is the statement of Archana Paul. And this, Millard, at page 86 is also the statement of Archana Paul. So, Millard, this is the same set of bank statements which we had disclosed. After this, Millard, we wrote to the bank so that, Millard, they certify it. And those letters, Millard, are from the next page, page 87. Your Lordship will find, Millard, I'm so sorry, Millard. This is our letter of eviction to Bata. Lordship will kindly see, Millard, the letters which we have given. That is, Millard, from page 107.
Yes.
Millard, your Lordship will also see here, Millard, page 107. We are requesting for attestation of the bank statement.
This is after the filing of the suit.
After the filing of the suit, Millard.
So this
because the stage of evidences will now come.
Yes.
107, 108, and so long, Millard. And this runs through till page 120. 6 bank accounts. We have made requests twice to each bank.
Okay.
For requests so that they certify and attest and give us the bank statements.
Yes.
After that, Millard, they provide us the bank statements with only the stamp page 121 onwards.
Yes.
121 till 142.
Yes.
Same bank statements have been only stamped. Now, Millard, if your Lordship permits me, I can only rely on these. These are the same things. But, Millard, if we see the Bankers Book of Evidence Act, particularly Section 4, definition of certificate, and, Millard, Section 5, that, Millard, requires a particular certificate. And these, Millard, your Lordship will appreciate, these are not computer-generated bank statements. Neither are these certificates, these are only stamps. So, Millard, we have requested the bank to provide us with these certificates. Now, Millard, the law gives me a right to make an application before your Lordship so that the bank is directed to provide me with these certificates on the account statements. If your Lordship kindly takes up the Bankers Book of Evidence Act once, Millard, I will just place Millard, section 6. I'm to please put it. Well, as such, we may not have any difficulty in this undefended suit because there is no one to oppose the exhibiting of a document. But as your lordship knows, Milord, a stage may come after the decree is passed, then these issues of setting aside may creep in. So, Milord, will kindly have a look at the Bankers Book of Evidence Act, section 6.
You are having not?
Milord, I have my copy. May I hand up, Milord? Section 6, Milord, gives us, Milord, there is a definition under section 2, subsection 8, certified. What do we mean by certified copy? And section 6 gives me gives Milord empowers the court to direct the banker to provide me.
No. See, how many banks are there?
6 banks. 6 banks accounts. But
No,
essentially
6 bank
3
accounts
banks.
of the only one bank?
No.
Ah.
Different banks.
Different. When
State Bank of India, Punjab National Bank,
So
UCO Bank.
examine the witness. Call the
Milord, then the banks, Milord, the bankers are not parties to this matter.
Not necessary. As a witness.
And Lordship Milord will kindly see section 4.
Correct.
The certificate is good enough.
That's correct.
And
That's correct.
unnecessarily summoning them as witness is not Milord, permissible under law.
No,
Because
but kindly come to 141.
Yes, Milord, page 141. Yes, ma'am. Yes,
But
this
yes.
document is signed on the specific request.
He has not certified this is a correct and true and correct.
No, Milord, actually the thing is, these are not certificates at all.
Correct, that's
so
why.
the banker has, Milord, the banker says that you get, now what has happened is, and I have pleaded this in my application, the banker says you get an order from the court, we will do it, because they are aware of the provisions of Bankers Book of Evidence Act. They are aware that the courts may direct them. Milord, I need to only show to your lordship that I have made bona fide attempts by writing letters to them. Milord, my letter has resulted into only stamping, but it requires certification of the same bank statements which I have originally disclosed with the plate.
Yes.
So, Milord, this is one of my requests. Your lordship will kindly come to the prayers, Milord. Which is at page 13.
Yes.
Milord, my first prayer is an order be passed granting leave to the plaintiffs to disclose and rely upon documents mentioned in paragraph 13. Second prayer, Milord, kindly, Milord, have a look at paragraph 13, Milord. Paragraph 13 begins from page 10, last line, and 11 and 12. Milord, I will make my submission with respect to item number G, that is e-assessment slip. I will come to that, Milord. But with respect to the bank statements, Milord, these are the documents which contains the stamp. So, Milord, my first prayer was that if it contains the stamps and if your lordship is satisfied with only the stamping, then I may not proceed for further request. But, Milord, as it appears, I want to play safe, Milord. So I have made, Milord, alternative prayer B, so that your lordship directs the banks alternatively, an order be passed directing the banks mentioned in paragraph 9 to certify the respective statements of accounts disclosed as annexure B to the plaint under the provisions. Yes.
Now you got this stamp.
Yes.
Original stamp is there.
Yes, I have.
So it will be, and your witness will be examined. So it will be come on evidence.
My witnesses can prove it.
Can prove it.
Yes.
Correct. With regard to if you are telling that in future what will happen. In future, if it is set aside, the total evidence has to be set aside and de novo
I only want to be safe in that. That's what I wanted to say.
You want.
Then your lordship, my lord, will only allow prayer A.
Correct, prayer A.
Because prayer A is actually, these are actually subsequent documents.
Correct.
I cannot say that these are the original ones. They
No,
contain the original
that
stamps.
was there, but subsequently obtained. So you want the certified by the bank may be taken on record.
Lord, this is my first prayer. The second prayer, Lord, will kindly come back to page 12, annexure E. Sorry, my lord, page 12, item G. This is the E-assessment slip. My lord, with respect to this, my submission is, this E-assessment slip, your lordship will find at page.
What is the E-assessment?
Yes, my lord, page 143.
Correct.
This is, my lord, a suit. This is a commercial dispute. Suit for recovery of immovable property. So, my lord, the specified value under section 12, that is the value on which I must pay the court fees, should be the value of the suit property. I also have another claim for recovery of money, but those are all ancillary reliefs. I have pleaded in my plaint that my claim is in excess of 10 lakh. I have paid 50,000 court fees. But below, this is the proof which would show that my property is valued at 1 crore 83 lakh, page 143, and I am well within the specified value. This is only, my lord, to show, and this is a government document.
So this document you want to bring on record?
Yes, my lord, and this is obtained subsequently in February.
That's all.
And my lord, one additional prayer, that is so that I can hold the witness action through commission prayer C. There are two, my lord, senior citizens, and my lord, if I can have all.
How many witnesses you are having?
3. I have mentioned that, my lord, in paragraph 15 of my application. The plaintiff state that it has the following individuals as
you want all the 3 to examine? All 3 persons of the plaintiffs?
Mostly because of the bank statement, my lord. Bank statements are of these 3 individuals, so I need to bring all of them so that they can independently prove their bank statements.
Yes. The plaintiff has filed the present application being GA Comp 2 of 2025, praying for allowing the plaintiff to disclose the document mentioned in paragraph 13 of the present application, and also prayed for a direction for appointment of commissioner for recording the evidence of 3 witnesses of the plaintiff as mentioned in paragraph 15 of the present application. Counsel for the plaintiff submit that. Mr. Rohit Banerjee, an advocate appearing for the petitioner, submit that the bank statement is already disclosed by the plaintiff in the plaint from page 46 to
annexure B to the plaintiff.
Annexure B to the plaint. But the said document was only a Xerox copy of the passbook, and it was not certified copy or sealed of the or original seal of the bank. Accordingly, after filing of the present suit, the plaintiffs have applied before the bank for getting the certified copy of the bank statement of the passbook, and the bank authority, though have not certified the said passbook, but have put their seal and signature in the passbook. Accordingly, the plaintiff intend that instead of the Xerox copy of the passbook, they want to bring the passbook in which the bank authorities have put their seal and signature. The plaintiff is also
not the passbook, the bank statement.
Bank statement, but the passbook must go. But your bank officer stated that passbook.
That is whatever is the document, we'll bring it original.
The plaintiff is also intend to bring one document to which the plaintiff document, that is E-assessment slip. E-assessment slip, which has been obtained by the plaintiff after filing of the instant suit, which is appearing at page 143 of the instant application. Counsel for the plaintiff further submit that the 3 witnesses, that is Archana Paul, Soris Paul, PAUL, Bani Paul is to be examined on commission. If other submitted, out of the three witnesses, two witnesses are the aged persons, and as such, it would be appropriate if if an advocate commissioner may be appointed for examination of the said witness on commission. Heard the learned counsel for the plaintiff peruse the materials on record. This court find that the plaintiff has disclosed the bank statement in the plaint being annexed B, but now the plaintiff intend to bring the said document which has been in which the bank has put their seal and signature, and the plaintiff is also intend to bring the e-assessment slip which the plaintiff has obtained after the filing of the suit. In view of the above, the plaintiff is allowed to bring on record the documents as mentioned in paragraph 13 of the present application, which reads as follows. यहाँ से लेकर के ना पेज 11 से लेके पेज 12 का जी तक, ठीक है. This court find that the suit is proceeding undefendant against the defendant, as the defendant, in spite of receipt of the writ of summons, failed to file written statement. It is a specific case of the plaintiff that two of the witness are old age persons, and it is not possible for the witness to come before this court to adduce evidence. In view of the above, who can be appointed?
For any junior member of the parliament.
Junior member, who can be junior member? Ladies, give the name. I don't know. All you are.
May I suggest a name?
So and so appointed as commissioner for examination of the plaintiffs, three plaintiffs witnesses, namely Archana Paul, Soris Paul, and Bani Paul on commission.
Milord, one more request, Milord, or any further witness, or any further witness, Milord.
Or any further witness if the petitioner intend to, or the petitioner intend to examine on his behalf to prove their case, in their behalf to prove their case. The remuneration of the commissioner is fixed rupees 1500 per sitting. 1500 per sitting. 15,000, not 1500. 10,000.
Yes, kindly.
10,000. 10,000 per sitting. Full stop. The commissioner is directed to inform the date of examination of the plaintiff witness on commission to the assistant registrar of this court in advance, so as to enable to produce the document by the officers of this court at the time of examination of the plaintiff witness on commission. Okay. The commission is directed to complete the evidence of the plaintiff witness 4 weeks.
No, Milord, should be 8 weeks at least, because there are 3 witnesses, and chief will be there, and these documents, Milord, 6 weeks at least.
Within 2 months, within 2 months from date.
No, 2 weeks.
2 months.
Yes.
4 weeks. 8 weeks.
Yes. Sufficient.
2 months. Full stop. The commission is directed to file the report July, August. of September.
So is that the last date?
Last but one day.
Okay.
Because otherwise then vacation.
Yes, Milord, last but one day.
25th of September 2020. List the matter on 25 for filing commissioner report. कोई एक को कर दो, मुखोपाध्याय को कर दो. Give the phone number of the.
Yes, my lord, I'll give the phone. I'm deeply obliged.
Disposed of. GA2 is disposed. You take your book. My lord, in this matter, my lord, I am appearing on behalf of an intervening applicant. Lord, GA5 is my application under Order 1, Rule 10, your lordship. Pleadings are complete, but the matter is not appearing today. Only
GA10 is not
GA6
here.
and 7, yes, my lord.
GA10 is not here.
$1 holding. Is that the matter where you're appearing for?
No, Sanjeev Infra Logistics.
I
Which
apologize,
matter?
your lordship.
$1 is at 2 o'clock. My learned friend did.
I apologize, your lordship.
Obliged.
Your Lordship, I'm appearing for the plaintiff. In this matter, a commissioner was appointed. The commissioner has submitted her report. She is virtually present, Your Lordship. On the last occasion, her payment had not been credited on that day. Now it is. She is on virtually. She is
Can I have my lords kindly leave to appear virtually, my lord?
Yes,
On the
yes.
19th of June, I submitted the report and my remuneration has been received, my lord. I may kindly be discharged.
Okay. So,
Right.
argument ready?
Your Lordship, I'm being led by my senior. We need one day, a time to be fixed. It'll need 5 minutes for arguments, Your Lordship. It's a very small matter. Everything else is completed.
And Commissioner, Advocate Commissioner is present through virtual mode and submit that she has received the remuneration accordingly. Remuneration, as she already filed the report after serving the copy to the learned counsel for the plaintiff. In view of the above, the commissioner, the Advocate Commissioner is discharged from the instant case. Counsel for the plaintiff prays for accommodation to argue the matter on some other date. In view of the submission made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on. Give the date. Yeah. कितना बजे? 12:30 खाली है. 28th August 12:30.
12. Deeply obliged, Your Lordship.
Number 9, my lord, I'm for the plaintiff, my lord. This was an application taken out by the respondent, my lord, that the disputes between the parties are not commercial and this should be rejected, my lord. I have placed an order that permits the same to be transferred to the non-commercial division.
So you want to transfer this?
Yes, transfer. Nothing.
Who is for the other side?
My lord.
You are for the plaintiff.
I'm for the plaintiff, my lord. This was the application. GA4.
Filed by defendant?
Filed by the defendant, my lord. My only thing I'm thinking that I'm enjoying an interim order currently, but that may be given to me for a period of 4 weeks at least or 2 weeks at least till I present the plaint before the non-commercial court.
But if it is withdrawn, how the interim order will continue?
But in the appellate order that I have placed, my lord, same liberty was granted, and my lord under section 151 of the CPC has ample powers to.
Where is that?
Yes, my lord.
The appellate court can give, but how this court can?
From para 21 onwards in the judgment.
How it can be? Court is telling that it can be transferred. Our other conversion to appropriate commercial division.
Yes. De novo, the suit will start only for the first time I present, the interim order will be there. If I can satisfy that court, the interim order will subsist, or is the same will vanish.
Discussion for the purpose of deciding the extension of interim order till its representation.
In this suit, the defendant has not filed a return statement, and now after transfer, they will get an opportunity.
That I can transfer, but continuation of the interim order is difficult.
Only for 2 weeks, or at least till the presentation of the plaint.
Without the plaint, how the interim order can? You can take that order from the appellate court. This court can't. How if the plaint is not in, baby is not there? How you can feed?
Only thing, the jurisdiction is as per this appeal order. I am only suggesting.
Appeal or appellate court, SAP, something can be done, but the original court, how the court can say the plaint is written, the stay can be continued?
Only thing that the appeal order suggests that it is only a change of nomenclature.
Yes, what is your submission?
Your Lordship, I appear in item number 9. I'm facing some technical difficulty, Your Lordship. May I just pray for a note today? On the last occasion, Your Lordship would recall that Mr. Shahu was leading me. We had submitted that the appellate court, possibly under Order 41, Rule 33, has such kinds of powers to extend the interim order. We had resisted my learned friend's application on the ground that it cannot be transferred by this Honorable Court. Your Lordship will just kindly mark this is not today. We'll come back and address Your Lordship physically.
Why you are not present today? Today the matter is listed.
Your Lordship, I understand, Your Lordship. I apologize, Your Lordship. I'm out of station for a professional commitment.
The transfer will be done if
processing. The defendant has filed the present application being GA Com 4 of 2024. Praying for
dismissal, madam.
Praying for dismissal of the suit on the ground that the suit filed by the plaintiff is not a commercial dispute. Not a commercial dispute. Full stop. The counsel for the plaintiff agrees for transfer of the case from this court to the non-commercial division and has relied upon the judgment passed by the appellate court in APOT 63 of 2025 with review number 31 of 2024 in CS Com 384 of 2024 within bracket Sudarshan Prasad Bangaria and another versus Arshavardhan Khemka and others dated 26th of March 2025, wherein the Honorable Division Bench of this court held that held as follows. Set out paragraph 21. Okay. In view of the above, in view of the judgment passed by the Honorable Appellate Court, the CS Com 677 of 2024 is returned to the plaintiff with the liberty to file before the appropriate court. With the liberty to file with the appropriate court. Full stop. The CS Com 677 of 2024. क्या बोला? अच्छा, sorry. The plaint is written. The plaint is returned to the plaintiff with the liberty to file before the appropriate court court. Full stop. The plaintiff, counsel for the plaintiff press for extension of the interim order, but this court is of the view that the plaintiff is returned, it is liberty to the plaintiff to move the interim application before the appropriate court when the plaintiff will file the same before the said court. In view of the above, CS consensus disposed of. Along
I pray, my lord, that this suit may be renumbered, my lord, as per this.
Department. That's a plaintiff return.
To the
Then you
department.
could go. The department will. Other will difficulty. Okay. CS sensu along with interlocutory applications are disposed.
But the interlocutory applications, my lord, would not kindly dispose of. As per this order, I am only praying the pleadings filed in the commercial division can be considered afresh upon the suit being presented. The nomenclature may be changed of the application. My lord, kindly grant me that liberty.
Is written. But this court is of the view as the plaintiff written. The plaintiff has liberty to move the interlocutory application along with the suit before the appropriate court.
After changes in nomenclature.
In view of the above, the case is dismissed. In view of the above, CS com is disposed of.
Deep level.
Sensu disposed of.
Deep level.
My suit, my lord.
नहीं उस लोग करेंगे हम लोग करने ना हम लोग डिवीजन बेंच उल्टा सीधा हाँ GA4 का साथ वहाँ चला जाएगा नहीं GA4 dispose of GA1 and the plaintiff will return. Yes.
Lord, may it please your lordship.
I was addressing your lordship. My learned friend had finished.
Just a small recapitulation, my lord. Recapitulation. Just 30 seconds. Lord, this is my suit for eviction on the ground that the defendants, my lord, are not tenants. They are trespassers under section 2G. They do not have any right. I have purchased the property, my lord, in 2014. Prior to that, the original tenant died in 2009. And, my lord, there has been no atonement of tenancy. So this is the premise on which, my lord, we have taken up this application under Order 13A for summary judgment. And second, my lord, exhaustive arguments were made by Mr. Chatterjee, learned senior advocate, my lord, who is leading me in this matter on the last occasion. Now, Mr. Kaur, my lord, will address your lordship.
Yes.
Lordship, I have already addressed your lordship on the valuation of the suit. Lordship, the suit has been brought before the jurisdiction. It's a suit under 2G of the West Bengal Premises Tenancy Act. The suit has been brought before your lordship on the basis that the valuation of the suit is 12 lakhs. Lordship, today they asked for a summary judgment without any evidence. Lordship, I had already placed Nandita Bose, 1987, Volume 3, SCC 705.
Yes. Nandita? Yes.
Yeah, Lordship, I will not trouble because I've already placed it, but just to recapitulate paragraphs 4 and 5, the plaintiff is entitled to evaluate the suit as per their requirements, whatever be the valuation. But whether the valuation is correct or not, it is something which they have to substantiate through evidence. Lordship, today they seek not to lead evidence. In the absence of evidence being led in the matter, the valuation of the suit stands as the valuation, that is the rent, annual rent, according to the Court Fees Act. Therefore, the rent being only rupees 45 and rupees 95, this court would not have jurisdiction. Lordship, paragraphs 4 and 5 are the relevant paragraphs. I will not trouble you.
You have taken note of it.
Yes. So that was the first point which had been argued. Lordship, I had also given the pages of the plaint. The suit has been valued at 12 lakhs. 12 lakhs has been assessed as damages, which is also a part of the plaint. Your Lordship will find that at page 45. Paragraph 56. The valuation has been, basis of valuation has been provided from its exterior. The plaintiffs were informed that the expense to restore the building would aggregate to a sum of rupees 12 lakhs. This is the basis of their valuation.
Yes. Page number?
Lordship, page 45, it's volume 1, page 45, paragraph 56. It's a part of the plaint, my lord.
Paragraph 56.
Yes, my lord.
The continued illegal occupation, not
Lordship, the last 7
building
lines.
would be aggregate of sum of rupees 12 lakh.
Yes, my lord. In fact, on an assessment made by an engineer who had studied the building on a preliminary property from its exterior, the plaintiffs were informed that the expense to restore the building would aggregate to rupees 12 lakh. This is the scope of valuation.
Yes.
And this is how they come to the High Court.
Yes.
Today, they choose to file an application
Yes.
of summary judgment without leading any evidence.
Yes.
In my humble submissions, if they don't lead evidence in the suit and they cannot substantiate the damages of 12 lakhs, the suit has been valued improperly and the suit is not maintainable before this honorable court. This is also from Nandita Bose, paragraph 4 and 5, because they have to prove their claim of damages of 12 lakhs. Lordship, the second point which I had addressed, your Lordship, just to recapitulate, was on the Commercial Courts Act. Lordship, as far as the suit properties are concerned, your Lordship will find that the schedule of the plaint, my Lord, your Lordship will find the schedule of the plaint at page 53.
Yes.
Lordship, the first schedule of the plaint is land measuring about 1 kata 15 chitak 29 square feet, situated at 3A Karimbagh Lane, Kolkata 700016, Police Station, Newmarket, comprised in holding number 143.
Correct.
No commercial premise, although this has been filed on the commercial side. Kindly turn over page 54. Lordship, Schedule B, shop room and workshop at measuring an area of 240 square feet, situated on the southernmost side of the ground floor of the two-storied building.
Yes.
Lordship, this is the only commercial space,
Yes.
which is measuring about 240 square feet. Your Lordship will kindly turn over to page 55.
Yes. Residential.
Lordship, it's a residential room.
Yes.
Your Lordship, I had argued on the last occasion that the Commercial Courts Act section 21C7 is exclusive. It has to be exclusively used for commercial. It cannot be, Lordship. I had cited also all the judgments, including your Lordship's judgment. I will not trouble your Lordship. 2017 SCC Online Delhi 10706, 2020 15 SCC 585. I will just give your Lordship the relevant paragraphs.
Yes, you are already given.
Yes, my Lord. I will not trouble your Lordship. 2017 SCC Online Delhi 10706, paragraphs 8, 10 to 13 and 18. 2020 15 SCC 585, that is the Ambalal Sarabhai case.
Ambalal Sarabhai is the main, because
Main
in that
case.
it is recorded that the exclusive. Yes, next.
Lordship, one more fact which I had not placed on the last occasion. As far as a commercial suit is concerned, the landlord had filed an earlier suit which they had withdrawn. Your Lordship will find that suit at page 139. Lordship, it's between the same parties. They knew it wasn't a commercial tenancy and it was not a commercial suit. It was a normal suit which was filed, which was subsequently withdrawn, and this present suit has been filed. Your Lordship will find one interesting fact as far as this suit is concerned. The prayers are at page 146. Yes. There's a prayer for a declaration that the plaintiffs, being a bona fide owner of premise numbers 3A Karimbagh Lane, PS Market, Newmarket, Kolkata 16, they had sought for a declaration of ownership, which is missing in the present suit. Identical prayers otherwise. Lordship, the suit was valued accordingly.
Yes.
The valuation of the suit will be available, what according to the plaintiff is the actual valuation of the suit.
Yes.
And they are bound by this. Today, they can't just randomly come and say the suit is valued at 12 lakhs and then bring it before the Honorable High Court.
Yes. What will happen if the parties commercial, parties non-commercial, where the suit will go?
I your Lordship's decision, it cannot be before the commercial division. That is what I was relying on. I believe it's still something that needs to be finally adjudicated upon. But till such time, we are covered by your Lordship's judgment.
Yes.
Lordship, there is one last point which I had not placed on the last occasion, for which we had taken time. We have a prior suit. The tenant had filed a prior suit. Lordship will find the prior suit at page 366.
Who filed the prior suit? You.
We filed the tenant filed the prior suit.
Page?
Lordship, 366. It's in volume 3. Your Lordship, you will again find the parties are identical. Lordship, at page 366. The parties are Sheikh Muhammad Ashraf, Sheikh Muhammad Afzal, Sheikh Muhammad Iqbal, Sheikh Muhammad Imtiaz. Lordship, the identical parties as in the present suit.
You filed this suit.
Lordship, we filed this suit. And Lordship, against the plaintiff herein, who's the defendant in that suit.
Okay.
Your Lordship will find the prayers at page 373. Lordship will find a decree for declaration that the plaintiffs have every right to use, enjoy, possess, and or occupy the suit premises, and the defendant numbers 1 and 2 have no manner of right to dispossess and or evict the plaintiffs from the suit premises forcefully and illegally without due process of law. This suit is pending as of date. This is a prior suit which is pending. During the pendency of this suit,
what is the stage of this suit?
We had filed an Order 7, Rule 11 in this particular suit filed by the defendants on the ground that this is a commercial dispute and other grounds. The learned trial court has heard the matters for both the parties and has kept it, reserved it for verdict on the Order 7, Rule 11. So it can go both ways.
So if it go against you, what would be the effect?
It would not have any effect. We would it would not have, because they are the plaintiff. That is a suit for declaration. This is a suit for eviction. I understand that we are not on cause of action. It is the matter which needs to be identical. But here the matters are not identical.
That is not.
I have
they're not praying for the section 10.
Then it doesn't have any other relevance in my suit. If it is only section 10, then it may have some relevance. Other than that, it doesn't have any other relevance. It is a prior suit by them. They are asking for declaration and injunction. I was the one who conceded before your Lordship that there is injunction in their suit. There can also be an injunction in my suit, where I will not be disturbing them with their possession. I am the owner. They are claiming to be the tenant. I don't want to disturb their possession because I want an eviction in due process of law.
Go for this mediation.
But if they are ready to pay rupees 3 lakh per month, then we are ready for
sending it to the mediation. Go for the mediation for the president.
My instructing advocate is not in that spirit, to mediate.
Now the Supreme
Too much of heat.
Now the Supreme Court is harping upon the mediation. Go to the mediation. Settle it if it is not. I am not sending the record. Only the parties will be referred to the mediation. Go and.
But after today's arguments, we would get a chance to give a short reply. In the meantime, I will obtain instruction and come back to your Lordship, maybe early next week, for a formal order whether we go for mediation or not.
No,
but it should be be a positive attempt from both sides.
Correct.
So that it can be settled. But there would be one difficulty, Mr. Court would agree with me. Here, the people are staying in the property for a very long time. And usually when we find that people are staying in a property for a very long time, it's difficult to detach them from that space, even if we offer money. So in mediation, let us see, when it is falling from your Lordship, we would attempt, definitely. After today's arguments, I will definitely take instruction and try to persuade my client. Yes.
Lordship, as far as the prior suit is concerned and the question which fell from your Lordship, if we succeed in the suit, we are declared as a tenant. Once we are declared as a tenant, 2G will not be applicable. This is where it comes. The scope of 2G under the West Bengal Premises Tenancy Act is that my father was a tenant. After the death of the father, the mother has expired and 5 years have elapsed and I am not entitled to continue in possession. This is the scope of 2G, which is the scope of my learned friend's suit. Today we come and we say that no, we have a suit where we seek a declaration. Lordship, the declaration is also because of, your Lordship might remember that there were different rent receipts which were produced. There were two rent receipts which was also the bone of contention. One rent receipt was in the name, I'll place here the rent receipts. One of them was in the name of the earlier generation. The next rent receipt was in the name of the firm itself. Lordship will find all those documents. Your Lordship will find it in page 27 of the opposition, my lord. Your Lordship will find this as the rent receipt and the name of the firm, which is dated 10th November 2006.
Page number?
Your Lordship will find it in page 27 of the AO.
Yes.
Your Lordship will also find the rent receipts at page 441. Lordship, that should be in volume 3, page 441. Page 440 and page 441.
There are two. Yes.
Yes.
SKM Ibrahim.
Yes, my lord. That
We
was
have produced this original. No?
Lordship, we have produced the original. We had produced the original, but these are the rent receipts. So there are conflicting rent receipts, which was also an issue. Lordship, so if we succeed in establishing that the rent receipt was issued in the name of the firm, then we succeed in our suit, in which case 2G is not applicable. Because of which, Lordship, my submission would be that this summary trial and summary decree cannot be passed because there is already a trial pending on the issue of whether they are the tenants or not. So 2G will not be applicable as long as
Yes.
2G will not be applicable as long as this rent receipt, which is annexed at page 27 of the AO, is held to be invalid.
Yes.
Lordship, that was my submission as far as the valuation of the, sorry, my lord, as far as the prior suit is concerned. And this prior suit, until and unless it's disposed of, this proceedings cannot be dealt with.
Okay, let it stop here. Hey, fixed matter है क्या?
Next.
Counsel for the defendant has argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter appear on 5th August.
But if I believe the next matter will not happen, then we can.
I don't know, it may not happen. Not for my fault. Look at the next matter. Kindly see the last order.
On my account, it will not happen.
Huh?
On my account, it will not happen. I shall indicate why. If my lord takes my lord's last order.
Who is for the defendant?
Yes, but I am for the defendant. My lord had closed my right to cross. I'm sorry.
Bolo.
My lord had closed my right to cross-examine the plaintiff's witness. My lord, from that order, my lord, we had preferred an appeal. The learned appeal court was pleased to hold that the appeal was not maintainable.
We took the point that it's an order passed under the Commercial Courts Act. It's hit by Section 13.
Hit with Section Order 43, not maintainable. The learned appeal court has given us a liberty to take steps in accordance with law, albeit that is not a liberty per se, because that was anyway available. I would have been praying if today my lord has fixed for witness action of my witness. I would be praying if my lord would be kind enough to.
I am closing your witness action also.
Adjourn the matter today, my lord.
I am closing your witness action.
My lord kindly appreciates this.
No, sir, fixed time.
I appreciate, my lord.
If I am closing, if you get the total order, you get the total order from your.
But I would intend to file an application before my lord. No. May I just say this, my lord? That I'll be completely non-suited, my lord.
Every day I have to I said to say something on the ground of the evidence. None of the advocates are interested to proceed with the evidence.
May I just make
One or the other reason, either plaintiff or the defendant. I am not getting the suit disposed.
I apologize for the conduct on behalf of the defendant.
Okay,
May
I
I
am
just-
facing that this should be disposed of. You test the whole order in the appeal.
May I my lord will kindly.
Sorry, sir.
My lord will kindly not do that. My lord, kindly give me one opportunity, my lord, to come back.
Record an order.
My lord will kindly, if may I just.
By an order dated 16 June 2025, this court has closed the evidence of the closed an opportunity for cross-examination of the plaintiff's witness by the defendant. For the interest of justice, the case is fixed today for especially fixed today at 11:30 a.m. for examination of the defendant witness. When the matter is called, counsel for the defendant press for time. Full stop. The press for time. Considering the above, this court finds that the defendant again intend to drag the matter and is not interested to adduce the evidence. Accordingly, evidence of the defendant is closed. List the matter for argument. Let the matter be placed for the argument.
My lord will fix a date.
Let the matter appear on 29th of August at 12:30 for argument.
My lord, may I make one submission? If my lord will kindly be pleased to, if it so commences, impose costs upon the defendant and allows me. My lord, I have
that 3 years I have done that cost, but that also not serve the purpose. Even I have put the 1 lakh rupees cost, that also not serve the purpose. You are putting the burden upon your clients.
Lord, I am
and the clients are paying the amount.
Lord, I am taking the burden upon myself.
No problem, sir. You come with the argument. I will fix whatever it.
My lord, kindly reconsiders the order.
Sir, but already
I appreciate, my lord.
Then
it is
June the order was passed. You could have been ready today.
Completely justified.
Then your appeal court has not accepted your appeal.
No,
you could have been. How this court can adjourn the matter?
The appeal was fixed today, and the may I just
yes
once again
call
the
नहीं होगा ना तो argument के लिए fix होगा.
May it please your lordship. Well, I am for the defendant. Well, application for amendment of written statement. I was supposed to give reply before your lordship today. Well, just before I give reply, well, a short recap. Well, initially the matter was decreed ex parte. Well, we preferred an appeal, secured the claim, and also paid cost. And direction was passed to file written statement. Now, what happened? The written statement which was we prepared earlier was not under the Commercial Court Act.
Okay.
So, we tried to
J7.
Yes.
Argument J7.
Yes.
Yes.
Now, we tried to comply, annex some document, also given some explanation.
When the suit was transferred?
Long time. Because it was rejected on the ground also.
Which for the defendant?
I am for the defendant. My application.
Which for the plaintiff?
I appear for the plaintiff.
Yes.
No, so now I now after filing the written statement, file this application for amendment. Now, in the amendment, they on last occasion, which created doubt, is that in respect of limitation, they agreed. Now they said that I have taken a plea that the goods supplied are not according to the specification. So they relied on a paragraph made in the application saying that there was a change of director and that is why that was necessary and it should not be allowed. They considered on the point of limitation, correct? Considered on the point of limitation. Now, I just want to, in reply, to show your lordship that that was a consistent stand and there has been no new case advanced before your lordship. That would be my endeavor before your lordship. Although, in the notes of argument, I have also disclosed argument that I can also, submit in the amendment of written statement a contradictory stand also. Now, kindly take the supplementary affidavit once just to demonstrate before your lordship supplementary affidavit filed by me, where my lord, the amended plaint is there. My lord, straight away come to page 9. My lord, lordship 9, paragraph 5. Now, my lord, lordship says, I am placing this because that is the, my lord, I say that was the stand. That was my stand, my lord. I want to rebut their allegation factually. With reference to allegation contained in paragraph 3 of the plaint, it is denied the plaintiff supplied or sold goods in terms of the purchase order. So defense was there, dated such and such. The purchase order stipulated that earlier that the plaintiff would supply iron ore fines Fe 63 of 2000 metric ton. The iron ore fine supplied by plaintiff had Fe count 56. The price of 2,600 per metric ton specified in the purchase order was for fines having Fe content such and such. Having, very important, having supplied non-conforming goods, the plaintiff was not entitled to raise an invoice on contractual rate of such and such. And then, my lord, on this ground, my lord, kindly look the amendment I have prayed for. A copy of the purchase order is annexed. The invoice dated such and such, my lord, it was also there. Surveyor appointed SGS report that said, my lord, 56 count. And then we have to annex document. So we have to annex that. So, my lord, I asked this question to myself, my lord, where is the contradiction? But I just explained the stand taken in the earlier written statement, and that is all. Well, one document also show, well, that is my consistent stand. Well, initially they filed a winding up petition before the High Court. Well, the winding up petition was relegated to the suit. And in that also, my lord, we have taken the point. My lord, kindly have a look. My lord, there is written statement volume 2, if your lordship. Written statement volume 2 on behalf of the defendant. না থাকলে একটা কপি দিও এই যে এরকম দেখুন এরকম লেখা আছে দেখুন volume 2 now straight away come to well this is my opposition before my lord the winding up court my lord kindly come to page 148 first my lord 148. Yes. Lordship will find subparagraph G. Purported claim arises out of in connection with the purchase order. Then, my lord, 148 bola 148 volume 2. Then, my lord, written statement volume. The petitioner then, my lord, kindly come to next page I subparagraph. Upon receipt of consignment of iron ores on ascertained the iron ore and moisture content in the said material, appointed SGS as independent agency. Then, my lord, they find report saying that iron fines is lesser. Then, my lord, lordship will find company is unable to such and such. Then, straight away, K and L. The parties has agreed and contracted to supply iron of a particular specification, and the price was accordingly agreed between the parties based on such. It would not be out of place to mention price of iron ore entirely on the content of the iron ore fines. The price of such and such is agreed at specification of 63. However, iron supplied by the petitioner was found inferior grade and not in terms of such and such. So that is my consistent stand. They say now, my lord, to prejudice your lordship, a paragraph made in my application saying that my director has said that and that is why. Maybe I have written when there something has gone like this. But the fact remains that is my consistent stand in the earlier written statement also that, my lord, what I have stated. So, my lord, my humble submission before your lordship, forget about inconsistent stand. My lord, my amendment which I sought for is just, my lord, explanatory in nature. And lordship knows, my lord, in written statement amendment, the court is always lenient and, my lord, always lenient and, my lord, this sort of explanation, my lord, in my humble submission before your lordship, I am beseeching your lordship, my lord, that should be allowed. Trial has not started. Yes. And trial has not started also. Now, my lord, my writtenness of argument, I have given, my lord, the points categorically. and the judgments, just I want to indicate that again and close my argument. Written notes of argument is a thick one. Lordship will find. না 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 এটা না এরকম মোটা একটা মোটা আছে রিটেন নোটস যাতে জাজমেন্ট আছে জাস্ট মালাড
Yes.
Well, Lordship will find. I will just indicate the paragraphs because judgment I have already placed at the time of argument. I'm not going to waste your Lordship's time. Now, let kindly come to straight away page 3, paragraph 4. The proposition, 3-4 proposition we have advanced. It is evident from the proposed amendment that the nature and character of the defense made in the written statement has not been changed. The amendment sought for are explanatory in nature. Reliance I have placed. Moreover, next paragraph, are consequential in nature, do not change the nature and character of the suit. A judgment also given. Now, the last is the standard of allowing application for amendment written statement is much lower than the plaintiff reliance is based on such and such. And also, one thing, the correctness of the amendment cannot be gone into while considering the application. But this is my consistent stand on the even in the winding up proceeding, and that is why that was remanded back. They was relegated to the suit on the basis of these defense only.
Combined application for disclosure of new documents and amendment.
So my application is for amendment along with in terms of Commercial Court Act for disclosure of the documents that I have disclosed. Lordship sees the prayer made in my...
When the case was transferred from non-commercial to commercial division.
Then we did not appear. Suit was decreed ex parte.
That was the time we did not appear. There was a date or something.
No, then how this case has come here?
No, it was transferred.
That's why which date this was transferred to this court?
Appeal court. Just a minute.
Page 29.
Page 29 of my application. 29. Lordship will find page 31, last paragraph. No, 31. Lordship says, so it was transferred on 25th February, second paragraph, page 31, on 25th February 2019. On and from 2000, the suit can only be heard by learned single judge having determination, that is to say, in a commercial suit. A separate list of commercial suit was to be...
Yes, then, page 32, taking into consideration the aforesaid factor, the time to file a return statement extended 3 weeks from the date of circuit of payment
subject to payment of cost, 2 lakhs paid, cash security 50 lakhs paid.
Correct. So when you file the return statement,
well, so when we filed it then and there. We filed
praying for amendment.
Now we are paying for amendment of the written statement.
তখন যে written statement ফাইল হয়েছিল ওখানে annexures ছিল না because it was...
Well, I tell your Lordship, I am thankful to my junior. Well, in earlier, we were not supposed to disclose the documents and also statement of truth and everything.
No, not that. That's why that is the point here.
Subject to correction, perhaps my learned friend had not filed a written statement. They had not filed a written statement. There was no written statement on board. They had probably prepared a written
amendment.
They had probably prepared a written statement.
Because then if you were given the liberty by the division bench to file the written statement,
copy of the
if you file the written statement and you disclose the document and the document is prior to the written statement, how this court has power to rely on that? That is the only question here. On the last occasion, I also put the same question to you. The appellate court has granted you 3 weeks time.
Correct.
With the cost of rupees 2 lakhs.
Correct.
Correct. So when you file the written statement,
well, we came to file written statement that was with the documents.
Where is the document? Where is the written statement? That's why I want to see where, in terms of the appellate court order dated 4th July 2023, 3 weeks time is granted. Where is that written statement?
I just, Lordship, kindly come to Lordship's order. What happened, here, we came up with the all documents. They objected. Kindly come to page 35.
I am asking a simple question, a layman question. When you file the written statement in terms of the division bench order of the 4th July,
My lord, we filed it after another order of division bench dated 20th February 2020.
Where is that?
Kindly come to page 39. But we were really confused with the situation. What is to be done? Well, let's see. This is an application.
On, you're not confused. You will become smart. You came with you taken the order from the division bench and came here with another written statement which you are undertaking in the division bench. Then this court has not accepted. Then you went for the clarification. The High Court has, the division bench has given liberty. Now you have to file only the old written statement which you relied at the time of hearing of the appeal. Then you file that. Where is that?
That court said no clarification is required. You have to file that.
Oh, that we have filed.
That's why I'm asking where you
have filed. Well, that we have filed.
So where is that?
Where is that? File করেছি তো
সেটা
we have filed that and thereafter we are praying.
That's why if that was filed and this document which you're relying upon that is prior to that written statement, how this court can allow that?
Absolutely.
Well,
it is by submission.
No. In the earlier plain
Order 11, Rule 7 or Rule 8?
Please, kindly have a look
of the amendment.
I tell you, Lordship, এই আগের সুটটা কোথায় আছে? Annex করা? আগের written statement টা কোথায় আছে? The earlier written statement, the documents to be relied on, it's there. Is there documents to be relied on? আগের written statement টা বের করো। Kindly have a look. Grant me a moment. In the earlier written statement, we have disclosed the documents to be relied on. It was written there. And that is why we are delaying, because at that juncture.
That's why where is that document? So these documents are not relied upon.
Well, এটাই ওই written statement যেটা ফাইল আছে।
Well, Lordship,
that is the original written statement that was shown to your Lordship.
Well, Lordship, this is earlier written statement.
No, this is not the complete ভুল বলছো দাদা, এটা নয় ওটা।
আরে এটা আফার্ম হয়েছে আগে
গেছে লোক ফাইলিং এর আগে
রিফাইল এটা রিঅ্যাফার্ম কপি অরিজিনালটা আমি জজ সাহেবকে হ্যান্ডওভার করেছি।
ফাইল হয়নি তো ওটা আফার্ম ছিল।
You had shown that only to the appeal court, then
Lordship, kindly come to
এটা ওল্ড
এটা this is that old.
আচ্ছা old plain
written statement.
Kindly come to the old written statement.
হয়নি। This was never filed.
Well, now
this is what I have handed over.
Lordship sees the documents to be relied upon. I am not cause papers. Lordship says kindly come to page 11.
Cause papers
of order APOT 71 we are disclosing. And documents correspondence with Soneco marketing, that's we are disclosing here.
Correct.
Well, Lordship is asking a point to me. What has fallen from you? Can you rely on the documents which you have not relied in the earlier written statement? Now, in the document and that point of time in the written statement, we are not supposed to disclose any documents. All we have to do.
No. See, again you are misrepresenting.
No.
This written statement was not.
I can be ignorant of law, but I never misrepresent.
No, this written statement. This is the commercial. This written statement is filed in the commercial division. This because as after the order of the division bench, this suit has become commercial division. And the written statement.
Kindly come to the first order. It was made ready, but it was not filed.
Correct.
It was made ready, not filed under the old act. Lordship sees in the Lordship sees the
yes,
ordinary original civil jurisdiction.
Correct. I am not telling that. Lordship. I am not telling that. You have taken the leave from the division bench to file written statement. Your written statement was ready.
Yes.
Correct.
That is
if I am not wrong.
Yeah, that is the recording.
If I am not, if my memory is not lost.
Yes, that is.
You have taken taken before the division bench. Your written statement was ready, but due to inadvertence, you could not file. The division bench has allowed you. Okay, you have taken the stand that your written statement was ready, but unfortunately, it was not filed. The court has granted you to file the written statement with the cost. Then you came before this court. You came before this court, not bringing that written statement. You have brought another written statement. When you file that, the counsel for the plaintiff has raised objection stating that as per the statement made before the division bench, this is not the written statement. And this court has accepted the submission of the plaintiff and your written statement not accepted. And with the rider, if you come with the old written statement, this court will be accepted. Then you went for the clarification.
In the
before the division bench. Division bench has clarified. There is no clarification is required. The learned single judge has cried. You have to file the same
same written statement which was you affirmed, you relied in the division bench.
Yes. Kindly,
Correct.
kindly.
Now, at the time of filing of that written statement, have you taken leave that the document is to be filed?
Lordship.
That written statement which you have relied upon before the division bench, and after the division bench has already stated no clarification is required, you file this written statement. Correct. You filed a written. In this written statement, you are not crave any leave to file the documents because this was affirmed as per the old non-commercial divisions or the CPP.
Now, in terms of commercial court order, we need to disclose all the documents.
No, that is the wrong. That is the not the interpretation. If you want to, if you had come because you have not disclosed the affidavit of document along with this document, this
May I
written
allow my
statement.
junior to, because there is some gray area in my mind regarding the,
May I with my
regarding the chain of facts.
senior friends.
Chain of facts. I have.
If your lordship kindly takes a look at this document, this was the written statement affirmed.
I had handed over.
Yes, but this was the written statement which was lying affirmed when the appeal was moved. This we showed to the court.
Correct.
The court considered that an affirmed written statement is there, so allowed our prayer. But when that prayer was allowed to file written statement within 2 weeks, because it was not in a Commercial Courts Act format and with the documents, we filed a new written statement before your lordship, which your lordship rejected. Because that was not the written statement which the division bench allowed us to file. That is the ground on which it was rejected. So, my lord, we went to the division bench, sought for a clarification. The division bench said, and may I place that order, which said that you have to file that original written statement.
Correct.
So, we filed that original written statement.
Correct.
Because that did not mention any annexure. After filing, we are filing this amendment application.
That's
because
why
in that
written
statement,
which you have filed, you have not filed the order 11, the list of documents.
no, because we have filed that immediately, we filed the amendment.
When-
Because otherwise,
Because leave was also granted.
because pleading is not there in the
Where
written
is
statement.
the second order of the
My lord,
division
kindly
bench?
come to page 40. My lord, that is the reason, my lord. Also, leave was granted, my lord, for amendment of the written statement, so that
No leave is granted. If law permits, law doesn't
We
permit.
do not find any reason to clarify our order. However, this court shall
my
not
lord,
prevent
kindly
the
come to
appellant to
come.
pray for amendment. Shall not prevent the appellant to pray for amendment of the written statement. According to
In accordance
whatever
with law. Law doesn't
must
permit.
record the order dated 5th is not is under challenge.
That what we are doing now to make it in conformity with the commercial court order and all.
Kindly for 1 minute kindly the next page. তুমি এক মাস আগে আর্গুল করলে তো আমি বুঝে থাকবো।
Submitted the in spite of the diligence, advocate on record unable to obtain the original written statement of a It
What
will
it
be
would
open
be
for the
open for
appellant
the
take out the appropriate application for producing the original written statement by the erstwhile advocate on record. Till such time,
Shall be
matters
treated as
resolved, the
original?
photocopy of written statement shall be treated as the original photocopy of the written.
Kindly come to the next.
So copy was fine.
Kindly come to the next page.
In the event the present written is not conformity with the commercial rule, the defense also take a step, bring the written statement conformity with
So
the
they brought it in conformity and filed.
So
Yes.
this is
Thereafter they can't take advantage of another correction.
Yes.
This is why we taken out
This is the leave and they have obtained the
No, now, my lord, kindly, my lord, there has to be a conjoint reading
Sir,
of what.
I am telling, I will allow your amendment, not the document. Because kindly see the page 41. You filed the written statement without confirming with the amendment Commercial Court Act. You could have been filed the affidavit of a document along with the written statement. No leave was required at that point of time at the time of filing a written
My
statement.
lord, my submission, my lord, just make a conjoint reading of, my lord, or page 40, paragraph 3,
Correct.
along with page 41, last paragraph. Then
Yes.
everything, according to me, my lord, I can.
Correct. Kindly now you justify your last paragraph of the page 41. You justify. Can this allow you to file amendment, or this allow you to file the return, the order 11 rule, order 11 rule C of the amendment code by one affidavit the document is to be disclosed along with the written statement?
My lord, I don't.
Annexure তো ছিল না,
My lord,
annexure করা
under earlier written statement, there was no annexure. Earlier written statement.
Earlier, I am not on written statement. That's what I'm telling. I am accepting. 2017, you drafted the written statement. I will allow your written statement for amendment. But the document, I will not allow. Document, the binding on 41 and binding on the order 11, amended portion.
Every case, everybody will come and file do this in a commercial.
Then
You have
we
not
will
filed,
file
you have not
another
filed the affidavit of document.
Well,
You have not filed the affidavit of document along with the written statement.
affidavit of documents.
Affidavit of document, how to have been filed in the commercial division in terms of the Commercial Court Act. Along with the statement of truth, you are not given all these things.
None of my documents were annexed to the written statement. So we filed that and immediately we filed this amendment to get all these documents. None of the documents were
kindly
annexed.
pardon me. Here what happens, when this order was passed, we just followed the order of page 41. We came back to your lordship, filed that written statement. Photocopy of the written statement. Then, we thought, on the legal advice which we gave, maybe it's faulty, maybe it's wrong, that it should be in conformity of the Commercial Court Act. Then, paragraph page 40, the leave granted, we filed the written statement along with all documents, so that it is at the same time comes within the conformity of the Commercial Court Act. Maybe on lordship is absolutely correct. In law, I have not done anything which is illegal. That I have demonstrated before your lordship. That is my consistent stand. Maybe the advice in respect of technicalities is wrong.
That's where is the justification, the document which you are having the possession and you file the written statement after taking the benefit of the division bench order. Why you not disclose the document along with the written statement? I am not a written statement. I am on the document. I am not on the written statement. Okay, I am satisfied with your submission. Written statement was old one, and subsequently you find no problem. Okay, but for how the document, because you are enclosing the document, and document is old one, and you are relying upon the company application of 2000. So that is the old document which you are in possession of the document.
Except, as far as I gone to the documents, court document, lordship can allow, lordship cannot allow. But it's a document of the court. I don't think how can they shut the door to disclose
neither they,
neither
the plaintiff, neither you not misinterpret. It is not the plaintiff nor the court is closing your door. You close your door of your own by not disclosing the document at the time of filing a written statement with the list of documents.
I would say, in that regard, lordship is absolutely correct, and I will not, join issue with that. I only can say, the way the learned advocate interpreted the order of the division bench, they proceeded with that. That's not a fault on the part of the written state, on the part of the litigant. That can be condoned. That's my submission before your lordship. With deepest respect, the order at page 40 and 41 was, for us, to be honest before you, was confusing enough.
Not confusing enough.
For me, and
kindly Mr. Gupta is.
So, we filed that. That was our joint call.
The statement did not mention any annexure, and it was
our joint call.
It was the photocopy which was directed to be filed, so we had to file.
No. I am 41 last paragraph. Present written statement is not conformity the commercial rule. The defendant shall take steps to bring the written statement conformity. That conformity written statement. The court has stated that written statement filed.
The amendment.
Written statement filed. So if you are filing the written statement, you could have filed the list of documents. That's all. You not then.
We have sought for leave.
That's why I'm asking. Only I am asking.
Kindly also come to the prayer. I was
sought for leave by way of this application to file these documents.
Lordship says kindly come.
It's not that we have just placed those documents on record, because our written statement did not have the annexures mentioned. List of documents did not have anything mentioned. So with the written statement, I could not have filed anything.
Kindly look at the prayer. Lordship, kindly look at the prayer. Confusion will be clear that the lawyers was even confused. Kindly look at the prayers of my application. First is, Lordship will find.
What happened to page 41? That is what I'm wondering. Court gave them the chance. They
Lordship,
still don't
Lordship sees the prayers. I will not utter a single word after that. Lordship will find from the prayer. It's
Master
Semester? Master Semester? Prayer.
join the prayer reading form में बचे. हमने तो लिखे जाएगा. prayer गुलो reading form में खुद I am accustomed with
sometimes, client may come and go, I have to be fair before your lordship. That is my first understanding. Lordship sees the proposed amendment indicated in the rating in the copy of the such and such yet to be allowed. That is supplementary affidavit. Some defects were that with defendant permitted to leave to re-verify, reaffirm. Then leave be granted to statement of truth affidavit as per Commercial Court Act. We file this with a saying that I want to make this with conformity of commercial code. And so, my lord, I don't know, my lord, I will not say anything. Now I'm leaving it to your lordship, my lord. From the prayer, it is clear that what was going through our mind at that point of time while drafting this.
Okay.
So, my lord, I submit. Reply.
Yeah, last Lordship had had it for before 1 month at least. I just finish in 3 minutes. I'll finish it.
I'm grateful to you, Lordship.
Thank you.
I will not file a supplementary affidavit, not waste your Lordship's time.
Supplementary
their
affidavit?
judgment. They are new judgments which they are supplementary written note. Sorry, dealing with their new judgments. That is one. I'm got two submissions on this. One is page 41. That last paragraph of page 41 is very clear. The appeal court grant. Second time the appeal court granted them the leave to file within the conformity of. They did not choose to do it. They just file a written statement, and now they are again taking the same opportunity. And the second thing is that Lordship would consider their pleadings in the amendment application, where whether anything that they said here today is there, or even a single line of whatever they submitted today is there in this application. But submissions can be made from the bar, I understand, but not, I think go beyond the pleadings and every explanation given in the application. I'll file that one-page supplementary dealing with their new additional judgments.
You will also file?
No, I have comprehensive.
Record. Hearing in connection with GA2, na? GA7?
GA7.
Hearing in connection with GA7 of 2024 is concluded. Counsel for the plaintiff press for a week time to file supplementary written notes of argument. Let the supplementary, let the matter appear on 5th of August 2025 as to be mentioned for filing supplementary notes of argument by the counsel for the plaintiff. Yes.
May it please, Your Lordship.
Lordship, I appear
Lord,
on
I
that.
was appearing. Lord, this is that Order 7, Rule 11, which we were arguing. Lord, Dhanbad Fuels we had shown. Lord, 2 points we had taken. One, Lord, was that 12A is not fulfilled. No mediation process initiated. And Lord, second, Lord, this is the jurisdiction we had raised the issue that this is a bill of exchange where it is an export process from Singapore to India, and as such Indian courts would not have jurisdiction. They would have to initiate proceedings before the Singapore court. I had made the submissions on the first part. I had shown the judgments which culminated in Dhanbad Fuels, which is the last judgment on the point, and I showed that. The other part, may I be permitted any day, not next week. The other point, is the jurisdiction aspect, because it's a bill of exchange. So I was referring to the Negotiable Instruments Act, and I was arguing that today, if there is a dispute between the parties, then the bill of exchange was raised from Singapore. So today, if there's a dispute, they should have initiated a proceeding before Singapore courts, not before this honorable court. For that, kindly permit me some time. I'll come back and I'll show those judgments and I'll conclude. I'll not take more than 15 minutes. But next week, I'm in some difficulty. So may I only pray for, other than the next week, any day thereafter, I'll come and argue.
There are two other applications filed on GA1 and GA2 for Lordship, and I have sought to file opposition. I have seen extension to file that opposition.
What is the GA2, GA3?
There was one GA is where there's an interim order where it was not extended within time because they did not mention. So they are protected by your Lordship's order. Your Lordship has indicated in that order. So they stand protected. So, may I only come back and conclude my submissions?
But how long will this go on for, my lord? When its senior friend is here, he can argue. He had argued for a bit where he can conclude. When order
I'll
7,
conclude, any day I'll conclude in 10 minutes.
Not conclude today.
He will
Let him
conclude.
not
I want to be physically present and show these judgments, and I'll conclude, my lord.
For this, my GA won.
Mr. Bagh is telling that the court will not satisfied if he argue through the virtual.
No, my lord, no, my lord, not for
Louder
once.
and clearer on virtual.
I'll indicate, my lord, the difficulty. It's because my
I'll
lord, some of those judgments are not with us. That's the
Then
difficulty.
at counsel for the defendant number 1, prays for some time. Accordingly, case is adjourned. Some full stop. Counsel for the defendant number 2 and 3, prays for extension of time to file affidavit in opposition connection with GA1 and GA3. Time to file affidavit in connection with GA1 and GA3 by the defendant number 2 and 3 is extended for 1 week. For 2 weeks, reply if any there to be filed within a week thereafter. As regard GA, this is with GA. This GA4.
GA4 is for rejection.
GA4, my lord.
Let the GA4 be fixed on, be listed on 6th of August 2020.
Only concern is after GA4 is disposed of. If it is disposed of against them, then GA1 will have to be taken up. That's my prayer for
GA4 complete first.
Grateful.
No, I just hope, my lord, that stage doesn't come. I'm very deeply obliged, my lord. Very deeply obliged.
But 13, I appear for the defendant. My lordship had, on my prayer, extended the time for filing affidavit in opposition. There was nothing to say on the affidavit in opposition. I take instruction from my client.
GA1.
GA1.
Yes, my lord.
What is the GA1?
You know, it's an application for injunction. The matter is about recovery of money for goods sold and delivered.
But I'll tell my lord what my instructions are. But my client is ready and willing to pay the principal amount, which
I'm
is
sending it the mediation.
Lordship may send it. Lordship may send it. Because
My lord, if they are ready for
That's why I am sending it to the mediation. Let them settle the matter.
Lord, my client is not agreeable to pay the interest because interest is wholly disputed. It's not.
And you will pay the total amount.
But he has said
Principal
he
amount.
has asked for 4 installments, 4 equal monthly installments, 8 lakhs.
if my lord, I have
4
to take
installment, 4 weeks. 1
4 monthly one. 8 lakhs for that they had to file a suit. Lordship would understand my client's finances.
Only 8 lakhs.
Only
4
8
lakh,
lakhs.
1 lakh each week, 1 lakh.
But he can't. If he could, this suit wouldn't have been filed. He would have paid.
What do you want?
my lord, I have to take instructions whether
I am sending it to the mediation. In the meantime, if you also talk, then your client will come and both the client will sit with the mediator, then matter. The file will be here only. Only the mediation go and settle. If it is not settled, I will take the matter.
my lord, my only difficulty is since they themselves are saying that they are not in a good financial condition. So and there was an order directing them to file affidavit of assets as well, which they haven't yet.
Will not file.
Yes, my lord.
There's
So, my lord,
nothing
I
that
don't
is
know whether in the mediation process what will happen and what will they do with their assets. And probably even if I go ahead with the suit after the mediation fails, I may not be getting an effective decree against them.
Why? Why not?
And if they dispose of their assets or if they transfer their assets,
This court will remain here, then you will get the decree satisfied.
Well, the application is still pending.
If the in your favor is a decree, then the decree will be satisfied. That I can give the assurance if the court will remain. The determination will remain.
No, we trust and hope this will remain with the lordship.
my lord, if you think fit, if my lord can grant injunction against them not to dispose of the assets for the tune of the principal amount only.
Time before the mediator.
But the mediation not to alienate.
But I'll instruct my client to that.
Not to alienate any property.
I'll
Go to
instruct
the mediation. If not, then come in the month of August. If it is not settled, immediately mention. I will take the matter.
Lordship may not record anything. I'll write in my instruction.
I will write. This court find that Learned counsel for both the parties are present. This court find that this is a fit case wherein the matter is to be referred to the mediation for settlement between the parties. Accordingly, the CS Com 810 of 2024 is parties to the accordingly parties to the CS Com 810 of 2024 are referred to the mediation. The secretary mediation is directed to immediately appoint a trained mediator to settle the dispute between the parties and to file the report before this court by 20th August 2025.
My lord, if my lord thinks that
Please see
My lord,
that
I'll
I am
instruct
not
it
writing.
in writing. My lord, I'll instruct my client. My lordship may not record anything in the order.
ठीक है? Let the matter appear on 20th for report and further order.
Grateful, my lord.
Item number 14, I'm appearing on behalf of the plaintiff.
Yes,
I'm appearing on behalf of the defendant.
Your Lordship, there's an application for judgment upon there was a clear admission on their part. Your Lordship, I'm led by Mr. Shubhashish Sengupta has argued at length. Today he is not there here, Your Lordship. So
what do you want?
No.
Lordship, I'm led by Mr. Dudiman Banerjee. He is unable to attend the court actually today.
Who?
Lordship, we have Mr. Dudiman Banerjee, senior.
Yes.
Next Monday. Actually, Lordship, we haven't got any instructions from the client. We are trying to serve notices upon him. We will come back within 1 month if you seek adjournment.
I am sending it to the mediation.
Your Lordship, we have already gone to the mediation. After mediation, they have not appeared in the mediation.
Point of time also, we are suffering from financial losses.
Your Lordship, if they're accepting, my lord, this is not an ex parte order. My lord,
We are not accepting the fact right now, but we'll get within 1 month and place
Your
the
Lordship,
relevant
they have
documents.
already admitted to the fact that dues are outstanding.
And also, no, dues are outstanding, Lordship, but we have paid 18 lakhs, only 20 lakhs. We have paid 18 lakhs, 20 lakhs is remaining.
Your
We'll
Lordship,
pay, we'll get
interest
the
is
instructions
also
from
there.
our client, get within 1 month, my lord.
Your Lordship, on the last occasion also they have paid
Lordship,
for an
kindly give
adjournment.
one.
If they're seeking for an adjournment, my lord, may it be at time bound, your
Made me
Lordship.
within 1 month.
It cannot be 1 month, your
24
Lordship.
June you take a
Yes, your
time, but
Lordship.
the time was given
See,
to
as the High
24
Court got it,
July.
because I was also in the queue for a long time.
For what?
Today, your list is heavy, Lordship. That's why your list is heavy. That's why after several days, the matters came up. Like
I have no problem. If you tell which date, I will.
Your Lordship, already the last
1 month will
occasion.
come back with the relevant.
Your Lordship,
With the
that,
amount.
yes,
1
let
month.
them.
Demand draft or check.
Your Lordship, on the last occasion, if your
Lordship, you
Lordship
may
goes
pass
to the
necessary orders. You may pass
yes.
necessary orders if it is in 1 month.
Your Lordship, 1 month is too much. Your Lordship,
1 month,
that's
we are
Telling
we
that
are
he will come with a demand
because
draft.
my lord.
Lordship, he is actually
Then that
staying
makes
outside
secure.
West Bengal and we are unable to
Lord, we have
contact
also
him.
served the
What the
application.
business your client is doing?
Yes, Lordship.
What business your client is doing?
He's a contractor. Contractor would supply our products. Contractor.
Then
Lordship, still he's suffering like some political issues are being in a connection like at that place. So basically we are unable to contact him, Lordship. We'll come back within 1 month
My
and
amount.
with all the relevant documents, Lordship.
My lord,
Kindly pass necessary orders within 1 month, Lordship.
my lord, 1 month.
yeah,
Lordship,
admitted.
kindly consider.
When it's an admitted use. 1 month अपनी last date है ना 1 month बोल रहा this by submission ना
Yeah, it's right.
so you've already
Come on 13. Come on 13.
your lordship already they have got much time. It was supposed to happen 15th of July. Today we are on 25th of July.
24 June it was completed.
Your
That's why
lordship
it
is
was
supposed to come 15th of July.
We are unable to contact. That's the main thing.
Okay, come on. If they will not contact, then the court will contact.
Yes, your lordship may please to pass necessary orders. In default, your lordship may order may be passed. The necessary orders will be passed.
The matter is fixed today for hearing of GA2 of 2025, wherein the plaintiff has prayed for judgment upon admission. On 24th of June 2025, the plaintiff has concluded his argument. Full stop. And on the prayer of the defendant, the case was adjourned. Today also, when the matter is taken up, the learned counsel for the defendant prays for time. For the interest of justice, the case is adjourned. Let the matter appear on 13th of August 2025. It is made clear that no further adjournment shall be granted on the date.
Your lordship, only one indulgence. Some precedence may be given. Your lordship.
There only. No
If like your lordship in the last occasion that at the adjourn motion at the top, your lordship. Otherwise, they will again, your lordship, it will be.
Let the matter appear at the top under the heading adjournment. Come. Yeah, next.
Your lordship.
My lord, this is my application for summary judgment under order 13A, my lord. There is no defense, my lord. Goods sold and supplied, my lord. I have supplied, my lord. The defendant is Senko Jewelers. And my lord, in other matters, my lord, they started paying, my lord. Well, in principal sum is 37 lakhs 49,000, my lord. There were three invoices raised, my lord. Kindly come to my lord, page 23.
What is the instruction?
My lord, actually I have not received any copy or notice of summary judgment. Order 13A, that I have not received.
It has been served.
And
Affidavit of
it
service
is
has
wrong
been
to say that I have no defense because I have already submitted the written statement where I have already taken the written submission. I have already taken the defense. That's what is my defense.
The written statement was leave was taken, but it was out of time. It was kept abeyance, my lord, till subject to the result of this application.
No, my lord. No, my lord.
Yes, my lord.
Wrongly
They have obtained leave, my lord, before.
Have you filed an application for acceptance of the written statement?
My lord.
Where is that? Which application?
My lord, that application has been made and order was there, my lord. First of all, I mentioned the matter on the 72nd day that I have already affirmed the.
Okay, where is the application?
This
Which,
application has been served, my lord. On this,
no, their application for extension of time. Where is your application for extension of time?
This application is dated 19th day of June 2025. It is my application here.
What is the number? GA number?
I do not find it, my lord.
No, if it is number, why it is not?
It may be GA3, my lord.
I listed GA3.
Most.
It's GA3.
Actually,
okay.
As stated by my learned junior, it is GA3. It is not written here in my copy.
File written statement on the concerned section so that the written statement procedure. Yes. When you receive the writ of summons?
Writ of summons I have received on.
Have you received the GA3?
My lord?
Yes.
Yes.
I have received the writ of summons on 12th March, my lord.
12th March you received.
12th March. I have got it. Written statement I have affirmed on.
Why you not filed within 30 days? Where is the
that explanation is there, my lord. Actually, what happened after receiving the writ of summons, my client contacted the lawyer at Bankshal Court who usually conducts the 138 applications under NI Act. Since he is not the advocate of.
When you file the written statement? When you affirm the written statement?
I have mentioned it on, my lord, just a minute. Let the paper be with me.
Where is the written statement?
You not statement is here, my lord. That is.
When you affirmed?
I have affirmed the written statement on 23rd May 2025. That is 42 days after.
Have you filed the same in the department?
Yes, my lord. That has been done.
Where is the counterfile?
Counterfoil that has not been there, but the department as per. This is the order, my lord.
They obtain a leave from the.
That's what I want to see.
That is this order was given by Honorable Justice Partho Saruthi Sen during when your lordship was in Port Blair bench.
Justice Sagoto Majumdar, my lord.
Internationally kept it the record subject to outcome of the application and decision by the regular. Yes.
So subject to my application, result of my application.
Subject to their application for acceptance of the return.
Acceptance of their application, my lord. So kindly come to.
I have not received the.
If my application, my lord, succeed and a degree is passed, there is no need of a written statement, my lord. And they have not filed any opposition to my application, my lord. This application has been served on long back.
Unless I get the application, how can I file the? How can I file the objection, my lord?
I have filed affidavit of service.
But at the same time, it is my instruction from my client that, my lord, they have not received anything except the writ of summons, my lord.
Can I say this is the item delivered?
Yes, my lord.
My lord, I have
delivered on 29/4.
My lord, I have not got it. That is the instruction of my client and written.
So your client has not given to you.
No, my lord, that he has specifically stated to me, and in writing they have given that they have not received anything in respect of this matter except the writ of summons.
That is the standard submission every time. In every matter, this is the standard submission.
Not in every matter. Actually, in
those matters, my application, my lord.
No,
my lord, let there be a copy.
Give the copy. Give the copy.
I will file objection then.
My lord, may I show?
And my written statement will clearly.
One thing I want to show, my lord, kindly. My lord, kindly for order 13A, my lord, kindly see, my lord. When I file, my lord, they want kindly see, my lord, order 13A, section 3, my lord. The respondent may, within 30 days of receipt of notice of application of summary judgment or notice of hearing, whichever is earlier, file a reply addressing the matter set forth in clause A to F mentioned therein in any other form that represent within 30 days. They have to file in 30 days with reasons why this application should not be allowed. They have not filed any opposition.
Where is our affidavit of service?
I have filed my affidavit of service.
My lord, it is my instruction.
No, I will not allow. Affidavit of service here.
My lord, at the same time, my lord, it is my instruction, not in oral instruction, but in writing, written instruction, my lord. Written instruction.
I will take your written instruction, but the court cannot go beyond the affidavit.
My lord,
affidavit is there. What is your address?
Address is Senko Jewelers in
number. So give the number of your address. You are admitting the address of the defendant.
My lord.
You are admitting the address of the defendant.
Yes, my lord. Address is same.
168 of BB Ganguly Road.
Yes, my lord.
So that is there.
That is there, my lord. But at the same time, if I have already submitted the written statement, my lord.
Written statement
where I have already taken the defense.
Written statement is different thing. Chapter 13 application is different thing. They have filed it and then it has been served to you on 28th of April 2024. 29th of April 2025.
But if I don't get it, my lord, then how can the question of filing the objection arises, my lord? Kindly appreciate this aspect, my lord. And there would be no harm, my lord, no prejudice will be there if the application on the 13A is submitted to me, filed to me. And in that case, written statement and their application without considering my written statement, if that is allowed, my lord, and decrease passment, that will both be contradiction. Written statement there have taken specific defense, my lord.
Defendant is watching the matters from the fence, my lord, and there are 3 degrees which they allowed to be passed ex parte, and after they have come with the recalling application every time, my lord.
Submission, that is wrong submission.
Yes, my lord.
My lord, if affidavit is there, I cannot deny the affidavit is there. I cannot. I have to say that since it is on record, it is
in this matter, my lord.
Affidavit.
The check has been dishonored.
I have already. That is merit. That is merit, my lord. My lord,
the defendant has filed an application being GA Com 3 of 2025, praying for acceptance of written statement. Counsel for the defendant submit that the defendant has received the writ of summons on 12th of March 2025. After receipt of the writ of summons, the defendant has contacted the learned advocate and find that the learned advocate is at Bangalore for treatment of his wife. Accordingly, learned advocate and accordingly, the defendant has contacted the learned junior advocate of Mr. Siddhartha Shankar.
No, my lord. I had been there at that time in Bangalore. I was
contacted the junior of Mr. Siddhartha Shankar Sarkar.
No, Gargi Roy, my lord.
And as
Gargi Roy.
And as per her instruction, the defendant has provided the documents, and on receipt of the document, the defendant has prepared the written statement. By that time, the time to file written statement to file written statement of 30 days has been completed. He submitted though the defendant has not filed written statement within a period of 30 days, but has affirmed the affidavit on
23rd May, my lord.
But has affirmed the affidavit of the written statement on
23rd May.
23rd of May 2025. 23rd of May 2025. That is within
72 days after the receiving of the writ of summons.
Period of 120 days. Full stop. 120 days. Please further submit that as per the leave granted by this court, the defendant has submitted the written statement in the department subject to outcome of the present application. Full stop. Learned counsel for the number next. Learned counsel for the plaintiff has raised objection and submitted that no cause has been shown as to why the defendant has not filed the written statement within the period of 30 days. Full stop. Counsel for the defendant plaintiff further submit that The defendant, only to cause delay in the suit, has not filed the written statement within the specified period, and as such the application filed by the plaintiff and defendant is required to be dismissed. Is liable to be dismissed, not required, is liable to be dismissed. At the learned counsel for the respective parties produce the materials on record. This court, it is admitted, the defendant has admitted that the writ of summons was served upon the defendant on 12th of March 2025, but the defendant could not file the written statement within the period of 30 days. It is a specific case of the defendant that after receipt of the writ of summons, the defendant has contacted the advocate, but the advocate was at Bangalore for treatment of his wife. Subsequently, as per the advice of the advocate, he has contacted the learned junior advocate, and as per her advice, all the documents are provided, but within the 30 days, the written statement could not be affirmed. The written statement was not affirmed within the period of 30 days, but has prepared the written statement within the outer period of 120 days. Considering the above, this court finds that the defendant has shown sufficient cause for non-filing of the written statement within the period of 30 days, but has filed the written statement within the outer period of 120 days, and as such, this court is of the view one opportunity should be given to the defendant to file written statement subject to payment of cost of rupees 5,000 in the with the district with the High Court Legal Service Authority. Full stop. The written statement filed by the defendant in the department is accepted, subject to scrutiny by the department. The defendant is directed to show the payment of cost to the learned master within a week from date. The GA number 3 of 2025 is disposed of. Full stop. Number next. The plaintiff has filed an application under Order 13. Under Order 13A. 13A of the Code of Civil Procedure, as amended under the Commercial Court Act, praying for summary judgment. Full stop. Counsel for the plaintiff has filed the affidavit of service showing that the copy of the application being GACOM 2 of 2025, along with the documents have been served upon the defendant through speed post on 29th of April 2025. Learned counsel for the defendant submit that he has instruction that the defendant has not received the copy of the application being GACOM of 2025 or any document therein. File the application being changed. Considering the above, the plaintiff is directed to serve an extra copy of the GF2 of 2025 along with the document to the learned counsel appearing for the defendant in course of the day. Full stop. The defendant is at liberty to file affidavit in opposition within 2 weeks, reply if any there to be filed within a week thereafter. List the matter on 19th of August 2020.
One thing, there's a written statement is subject to the result of this application.
How GA3.
My lord.
Kindly see GA3. What is the GA3?
GA3 is there.
Then.
My lord, only one submission, my lord. Up to 19th August, actually, this
okay,
is my personal.
13th August. 13th August.
No. Actually, I have to stay in Bangalore for my wife's treatment.
So 13th August, I am fixing. When you are going to Bangalore?
As early as possible next week. Only for few cases I am here. So at the end of August, it should be.
Then I am hearing here.
I'll not be there, my lord.
What can be done? I am fixing after 3 weeks. You go tomorrow and come on 18.
That depends on the result of the treatment, my lord.
When you will be back?
The doctor can say, my lord. Actually, it is severe problem, my lord. Brain tumor operation, my lord.
Let it appear in the list.
Come on, let it in on the let it be in the list. If you appear, then your junior will be there. Then you take.
My lord, I am grateful, my lord.
Next.
Right on 16. Oh.
Yes.
My application.
I am for the plate. Your Lordship is taking fixed matter.
You're for the plaintiff.
No, I'm for the defendant.
Who is for the
This is
plaintiff?
my application.
What application?
Applications for amendment of written statement, my lord.
G3.
A3.
Yes.
If your lordship is pleased to take the application, look, the proposed amendments kindly takes paragraph 4 of my application once, my lord. 3 and 4, my lord. After submitting the written statement with counterclaim, the plaint and the written statement was made over to another address, such and such, within the existing period to carry out necessary amendment, and that
written
upon
statement with the counterclaim, the plaintiff written statement was made over to another.
effectively and conclusively decide the conflicting issues between the parties in this suit. Your petitioner submits that the proposed amendment shall not change the nature and character of the defense already submitted by the defendant, but such amendment will in fact enable the court to fairly and effectually decide the disputes covered by the suit. More so, the proposed amendments of the petitioner has not been attempted to withdraw any admission made in a written statement or change the nature or character of the defense. With the proposed amendments, my lord, with the deepest of respect, may we submit this, are in the nature of, my lord, clarificatory and or explanatory statements made in the written statement. Now, my lord, the suit, my lord, the suit there till date there's been no discovery and inspection. It is the only restriction would have been, my lord, with the deepest of respect. Correct me if I'm wrong.
I have been told that we have offered them discovery for 5 times by 5 letters. They have not chosen.
So it is at the stage of discovery inspection. So it is at the stage of discovery. Now, my lord,
where is that proposed amendment?
Proposed amendments, my lord, is at paragraph page 53. Paragraph which is forms part of, my lord, the preceding paragraph, which starts at, my lord, paragraph 48. 48W is what we have inserted. Pages 53 to, my lord, 67 are the proposed amendments.
Yes.
These are, my lord, the proposed amendments. Now, my lord, if your lordship is pleased to look into this, the pleadings, these are positive averments and they do not in any manner seek to withdraw any alleged admission. That's one. Two, my lord, with regards to the statements made in, my lord, the proposed amendments, the plaintiff is at liberty to file, my lord, the additional written statement if they want to. Thirdly, my lord, in case of a written statement, my lord, two important issues which the court will consider at the time as to whether, my lord, the written statement, amendment of a written statement should be allowed or not. First and foremost, my lord, whether I am withdrawing any admission. If, my lord, there's an admission in the written statement, it is there. I am not withdrawing any admission. And secondly, my lord, trial has not commenced. So, my lord, we are at a stage where neither the trial has commenced nor am I withdrawing any admission. Now, the third issue which might be raised by my learned friends, which in fact they have in their opposition, which I'll place for your lordship's consideration, is this, my lord, that the amendments, my lord, are of such a nature that it would be barred by limitation. Now, the question of limitation is, my lord, a question of mixed question of law and fact. Suit is of 2023. We are in 2025. So, my lord, as a counterclaim, I could have maintained this anytime after filing of the suit. Today, my lord, it's not barred by limitation. This is my respectful submission in case, and we have to address on that. But on the point raised by my learned friends regarding limitation and all other aspects, my lord, it is settled position in law that, my lord, in case of an amendment, merits of the amendment are not to be looked into. So whether a particular statement or an averment or a claim or a counterclaim, my lord, claim in case of a plaint and counterclaim in case of a written statement, whether it is something which would succeed ultimately at the trial of the suit or whether it would be barred by limitation, these factors, my lord, the court, while allowing an amendment, is not to assess. This is settled position in law, my lord. I'll assist your lordship with the judgments as well. Now, what is their defense to my application for amendment, my lord? First and foremost, my lord, 3C, page 4 of their opposition, if your lordship is pleased to consider. No facts are pleaded as none exist, nor are any grounds raised in the said application to even remotely contend that despite exercise of due diligence, matters facts ought to be introduced by way of amendment to the written statement counterclaim could not be raised earlier. The proposed amendment to the written statement, if allowed, will enable the defendant to make a complete volte-face and go back upon its pleadings and its evidence, taking the plaintiff's case completely by surprise. Proposed amendments, if allowed, would amount to introducing a new case or a new cause of action. Proposed amendment, if allowed, would alter the very nature and character of the written statement. Proposed amendments would do serious injustice to the plaintiffs. In any event, not necessarily the purpose of determining the real questions and controversy. Proposed amendment should be refused, as the plaintiffs cannot be placed in the same position as they were if the amendments are allowed. Amendments would cause the plaintiffs an injury that cannot be compensated in costs. Proposed amendments cannot be allowed without causing injustice to the plaintiffs. The defendant filed the written statement cum counterclaim on or about December 2024. Plaintiffs filed their additional written statement on 2nd of January 25. Defendant, upon coming to learn of the plaintiff's defense to the written statement cum counterclaim as an afterthought by way of proposed amendment, is endeavoring to prove upon its case, even to the extent of resurrecting claims barred by limitation and residing from admission made in favor of the plaintiffs. The defendant cannot be permitted to improve upon and better its case in the garb of an amendment. On this ground alone, the application filed by a defendant is liable to be dismissed. The admissions made in favor of the plaintiff, if the proposed amendments are allowed, will be withdrawn. Fresh suit on the proposed amendment would be barred by limitation. The said application is not in the proper form, not affirmed, verified in accordance with law. So, my lord, I'll deal with each of these grounds one at a time. Firstly, my lord, whether, my lord...
What is the ground you have shown for not finding this?
Yes, my lord.
Not reading this averment in the written statement.
2, 3, 4, 5. These are the ground. 2, 3, and 4.
Hurriedly.
Yes.
Hurriedly drafting.
Hurriedly drafting. And my lord,
counterclaim was made over to the advocate for his oral opinion at this juncture. A petition was read is include paragraph existing written. No, this is subsequently. That is only hurriedly.
That is it. Hurriedly, and my lord, it was naturally with experience, somebody comes to learn that this is something which has to be done.
Why you are not given? That is nothing. Only hurriedly.
Hurriedly is the primary ground, and the ground that it was perhaps not. It's not happily worded. It's, from what I understand, is this, my lord, that the proposed amendments which have been brought about in the written statement, perhaps, my lord, at the time of drafting of the written statement, were, my lord, the concerned advocate perhaps couldn't grasp these entire facts, my lord, and could not effectually encapsulate the same in the written statement. Now, my lord, with regards to a test of whether the plaintiffs would be prejudiced. Firstly, my lord, the suit, there's no commencement of trial. They have filed their additional written statement to the counterclaim. They also can have an opportunity.
What fact you want to bring on record?
Yes, my lord. My lord, even though, my lord, the merits are not to be gone into.
How it is necessary.
Yes, my lord. My lord, the agreement for which, my lord, I would actually perhaps.
As per your amendment, you have made a new plaint, I think.
No, my lord, it's not a new claim. It's
not claim.
Plaint. Effectively, it might be. Which is, certain admissions are made by me, which is not to be taken into consideration, my lord.
Yes.
Now, all these facts, my lord, ought to have been pleaded in the written statement, my lord. Though, my lord, essentially, my lord, these facts, my lord, whether they change the nature.
What is the suit for?
Suit is for eviction.
What is your ground?
Well, ground usual 111.
You are
106.
Initially 106, now 111. This is one very important, pertinent.
106, 111, both. That is the principal ground. So, my lord, there are certain aspects, my lord, which ought to have been there in the written statement, primarily in relation to what the agreement specifies. The term of the lease, my lord, provides for several benefits which ought to have been given to the lessee, which have not been given, as a consequence of which, however, we have made those payments. There's a counterclaim on that account. And, my lord, these are the principal grounds on which, my lord, the amendments have been sought.
Okay.
Now, with regards to, my lord, the scope of the written statement amendment, my lord, first is, my lord, the ground of prejudice, which, with the deepest of respect, I think, my lord, we are at a stage where they wouldn't be prejudiced because trial has not commenced. Even if they take the plea that because they have introduced the case as in their additional written statement, having relied upon, my lord, the additional written statement, having gone through it, now I want to take a stand, which would in effect render the additional written statement filed by them nugatory, or to the extent, my lord, it can be set off against my case.
So what the suit you have filed there?
My lord, in the city court. The declaration, usual.
Declaration as tenant.
Declaration injunction. The standard form, my lord, that happens. Lordship knows. Now, the other point with regards to withdrawal of an admission, my lord, if I have made an admission, that would continue to remain, because if your lordship sees the proposed amendments, it becomes a question whether I have deleted anything. There is no pleading which was there in the written statement which has been struck out.
Taken a new plea in page 49, last paragraph.
Yes, my lord.
Section 10 of the CPC.
That is the point in law, my lord. That is a point in law. My lord, even if I don't take this point, if a suit is barred under section 10 because of res sub judice, it would still lie.
So section 10, whether the section 10
it's a question of
section 10 can be a issue.
Yes. Section 10, whether, my lord, it is a suit, whether it's a subsequent suit or not, it's a question of fact and a question of law. The fact is only the test which suit was filed prior in point of time, whether, my lord, my suit was prior or their suit was prior. If my suit is prior, section 10, again, my lord, is there in the books of law, my lord, it's CPC provides for it. Even if I don't put it in the defense, my lord, I can always raise it. Now, whether, my lord, this inquiry, as has been sought to be introduced by my learned friends, my lord, in the opposition to the written, in the opposition to the application, as to what is the scope of the amendment, as to how the amendment affects their suit, all these issues, my lord, with the judgments are there, my lord, that merits cannot be gone into. On the face of it, my lord, the amendment is such, my lord, that it wouldn't prejudice them. My lord, the amendments do not take away any admission. Even if they want to say so, they can say so, because and on the face of, my lord, the amendments which we have proposed, there is no striking out of any particular paragraph where I have alleged something or I have admitted something, and, my lord, I have resiled from that in the proposed amendments. What remains is, my lord, with regards to whether they can be compensated, costs can be there, my lord, costs can be sufficient, they can be sufficiently compensated with costs. Now, insofar as, my lord, whether these pleadings are based on any relevant facts or not, that again, my lord, it's question of merits of the case. It's evident that there are facts. 20 pages of amendment couldn't have come in from, my lord, thin air. So naturally that's there. And limitation again, my lord, mixed question of law and fact. My lord, in support of my contentions, my lord, if I may just rely upon a few judgments. Firstly, my lord, that in case of a written statement amendment, my lord, the test is much more lenient than in case of a plaint. My lord, it's been settled since, my lord, I think AB and AMRO.
But if it is taken as a counterclaim, then it is again a plaint.
My lord, the counterclaim is there.
So it is treated as a plaint.
Yes, my lord. Even then, my lord, then in fact the test will be easier because trial has not commenced. Okay. Probably the only clock that could have been there is, my lord, commencement of trial. Even if it would have been at the stage of framing of issues, That stage has also not commenced. Though, my lord, I have checked the case status yesterday, it shows as framing of issues. Perhaps we have not arrived at that stage yet. Now, my lord, Justice Torun Chatterjee's judgment has been there, my lord. It's been long standing. I am actually inclined to place, my lord, two judgments of more recent times. Firstly, my lord, I would like to cite, my lord, 2017 Volume 8 SCC. Copy. Page 657. Paragraph 3 onwards, if I may place. The respondents, plaintiffs, have filed a money suit in the court of the sub-judge, Chabra, against the appellants for recovery of 41 lakhs. The appellants filed their written statement and denied therein the respondents' claim by joining issue on facts. Issues have accordingly been framed on the basis of pleadings. It's a case where, my lord, the issues have been framed. It appears that the evidence of the respondents is over and that of the appellants remain. The appellants filed an application under Order 6, Rule 17 of the Code of Civil Procedure, seeking amendment in their written statement by adding 2 paragraphs in their written statement. The respondents opposed the application. The trial court dismissed the application. The High Court in revision filed by the appellants upheld the dismissal, giving rise to filing of this appeal by the defendants. So, my lord, 3 important facts. 1, my lord, the trial had commenced. Secondly, my lord, the evidence of the plaintiffs were over. And, my lord, the defendant's evidence was about to commence. It is at that stage the defendants sought to introduce certain amendments to the written statement. It is not in dispute that the suit filed by the respondents against the appellants, out of which this appeal arises, is still pending. It is also not in dispute that the evidence of the parties is not yet over. In other words, the trial in the suit is going on. We have perused the amendment application filed by the appellants. We find, firstly, the proposed amendment is on facts. Like ours, my lord, this is also an amendment which is based on facts. And the appellants in substance seek to elaborate the facts originally pleaded in the written statement. Secondly, in other words, it's in the nature of amplification of the defense already taken. Thirdly, it does not introduce any new defense compared to what has originally been pleaded in the written statement.
Come to the third.
Yes, my lord. I'm not introducing a new defense.
Then section 10. And with regard to the pendency of the suit before
these are 2 facts which I have introduced.
No, that is that. Then if it is there, now then there will be an issue.
There will be an issue.
Then if it is,
my lord,
issue,
even if I don't introduce that in facts, my lord, even then it's a question of law.
No, that's correct. But
that, my lord, even as a suggested issue, I could have raised. Or, my lord, it's since these are court proceedings, that I could have brought to the notice of this court. So, section 10, whether the suit is barred by law or whether the suit is res sub judice,
different.
This fact, my lord, could have been brought. It is not introduction of a new case. Okay. Now, my lord, fourthly, if allowed, it would neither result in changing the defense already taken, nor will result in withdrawing any kind of admission if made in the written statement. Yes. Fifthly, there is no prejudice to the plaintiffs if such amendment is allowed, because notwithstanding the defense and or the proposed amendment, the initial burden, this is of utmost importance, my lord, the initial burden to prove the case continues to remain on the plaintiffs. So, my lord, whether these documents, whether my pleadings, my lord, even if these pleadings go through, even as a counterclaim or, my lord, as a defense, I have to prove it. Plaintiff has to prove his case. I have to prove my case. And it is only upon that it can be adjudicated whether, my lord, the defense raised is sustainable or not. Okay. So, my lord, proposed amendment of the defendants should have been allowed by the courts below rather than allow the defendants to raise such plea at the appellate stage if occasion so arises. In view of the foregoing discussion, the appeal succeeds and is allowed. This is 2017 8 SCC 567.
Yes. Next.
Now, my lord, one factual issue, if I may just indicate, my lord, for your lordship's kind consideration. If your lordship is pleased to see, my lord, the proposed amendment at page 51. the fact that the suit is pending was already pleaded.
Page 51.
Page 50, running page 51, my lord, of the application.
Yes.
Paragraph S. Under the aforesaid background, the defendant had already filed a title suit before learned third bench in civil court at Calcutta, being title suit number such and such. Plaintiffs are contesting the suit. So it is not a fact which I have introduced by way of amendment. This fact was before court before I proposed these proposed amendments were brought before this court. So the issue of section 10 could have been raised merely on the basis of this pleading in the written statement. It's already there. There's not an introduction of a new fact. Now, secondly, my lord, the other judgment which I want to rely upon is
Yes.
Below 2021, volume 2 SCC 210. If your lordship is pleased to turn to paragraph 12 of the report.
Para 12?
Yes, my lord. This was in case of, my lord, proceeding which had already gone to trial as well.
Mr. Ghosh, my lord, you stop here.
Very well.
My division bench.
No problem. I will come back. Any day convenient to your lordship, my lord.
Counsel for the defendant has argued at length in connection with GA3 of 2025, but due to paucity of time, hearing could not be completed. According case is adjourned. Let the matter appear on 12th August.
Lordship.
Lord, is your lordship fixing any time, my lord? If
Huh?
this application could be, is your lordship fixing any time, my lord? For
time
this?
then long it will go. September.
Lord, let it be in the list, my lord. We'll do it.
We'll do September.
Well, in fact, my lord, to be very honest, if matters done in the list, my lord, it will be taken up, I'm sure. My lord.
Deeply. No. Oh, no.
Can you play that?
application for contempt, my lord. Mr. Bose is leading me, my lord. He's virtually.
कौन रखा है?
My lord, come to your lordship's division bench order against which, my lord, the contempt arises. Your
Yes.
lordship will find the order is at page 31 of the contempt petition. P1, 31. Your lordship, my lord, it will come back to your lordship, my lord. This was that petrol pump matter where your lordship was sitting with Justice Talukdar in courtroom number 11.
Yes.
My lord, two writ petitions were heard. Upon exchange of affidavits, the division bench took it up and disposed it of. Well, the issue was the final clearance was not granted to the writ petitioner appellant despite having complied with all formalities. Why? Because a third party had raised certain objection regarding road Congress guidelines. Wrote certain guidelines of the Congress. Well, it was held in our favor, and thereafter, if your lordship kindly comes to the operative portion of the division bench order at page 45.
Yes.
But the last paragraph of page 45, which is internal page 15 of the division bench's judgment, the second last paragraph is if clause 4.4.3 and 4.4.4 of the Indian Road Congress guidelines stated above are read together, it can be said that the defect can be remedied. In view of the above, this court finds that the Public Works Department of the State of West Bengal has not adopted the IRC guidelines and have not framed any rule or sub-rule such and such and cannot be sustained. Then, the respondent authorities are directed to take appropriate steps for granting final clearance to the appellant for commencing operation of the retail outlet of the appellant within a period of 4 weeks from here, against this order, the other private respondent in my writ petition and the petitioner with the other writ petition went up before the Supreme Court. Lord, kindly come to the order of the Supreme Court at page 45 first. I stand corrected, well, 47.
Yes.
Initially, the division bench order was stayed.
Correct.
Then, the final order is at page 48. After exchange of affidavits before the Supreme Court and upon hearing the SLP of the private respondent, after hearing all parties to dismiss. Now, Lordship may I just point out here, my lord, your Lordship will kindly see for respondent, my lord, kindly see Archana Pathak, ASG, then Venkataraman, ASG. So, my lord, Bharat Petroleum, BPCL was represented in the Supreme Court as well. And before the Supreme Court, my lord, they contended that the stand taken, the subsequent stand taken by the BPCL was untenable. So, on the basis of that, Supreme Court dismissed the SLP. Now, my lord, my advocate on record of the Supreme Court communicates the Supreme Court's order, though they were present in court, but by a letter which is at page 50. For compliance of the directions contained in the division bench order, that is to issue the final clearance, which is at page 50.
Yes. So 52 paragraph 5, you have requested to comply with your.
My lord, right. So there are no compliance till today.
Yes.
So I was respectfully submitting, my lord, kindly issue a rule. Well, otherwise, division bench, Supreme Court affirm, they get represented in the Supreme Court.
Not issue, let the issue notice first. Issue the notice. Issue notice.
I leave it to your lordship.
This contempt application is filed by the writ petitioner on the allegation that the alleged contemners have not complied with the order passed by this court in MAT number 689 of 2020 dated 22nd of December 2022, which was duly affirmed by the Honorable Supreme Court by an order dated 12/11/2024. 12/11/2024. This court finds that before passing any order, an opportunity is to be given to the alleged contemners. Accordingly, the petitioner is directed to issue notice upon the contemners, returnable by 4 weeks.
How much time you take? Notice the local or outside?
No, my lord, all local, all local. I'll tell you, Lordship, my lord, this man has been suffering.
Correct.
My lord, he's put his entire life saving in this. So, my lord, I will request, my lord, kindly keep it after
2 weeks. Let the matter appear on when you be free. 2 weeks. 2 weeks after 2 weeks. 2 weeks. So 12 and this 12th of August. 12th August at 1 p.m.
deeply obliged, my lord, deeply obliged.
Right. Yes.
With respect to the defendant number 5, there is no direct allegation against us. However, we are supporting the contentions which Mr. Sen, learned senior advocate, had canvassed on behalf of the other defendants. In the event, we intend to file a written note. After perusing what Mr. Sen has put in the written note, we would be filing it before your lordship's court officers by Tuesday. For that, your lordship need not fix another date for us to file the written note.
No.
By Tuesday, we would be doing that.
So
I
I am
will
fixing
tell
on
your lordship whether we are filing the written note or not, because we actually do not have anything else to say, as Mr. Ghosh, learned senior advocate, had mentioned.
Counsel for the applicant and the counsel for the defendant number 2 and 4 have filed their written notes of argument. Let the same be kept with the record. Counsel for the defendant number
5.
Kindly
liberty till
live. Submit that he may be given liberty to file the written notes of argument by Tuesday. Let the matter fix CAV. Yes. In the meantime, the defendant number 5 is liberty to file the written notes of argument with the officer before this court on Tuesday.
My lord, I was appearing online on behalf of the petitioner.
Yes.
And notes have been filed by my juniors.
Thank you. Thank you.
Grateful, very good.
Yes.
The returning officer was to come back with the instruction.
Rains, we got caught up.
Yes, it's raining torrentially.
Yes.
But yesterday this was taken up.
Examine or
No, we won't.
you will not cross examine.
Proceed with the GA one.
You will proceed with the GA. So I will let the matter be fixed for argument. I will hear that your GA along with the final argument.
There is another GA filed by the Election Commission of India. We have not been served with that.
It's not listed. Listed नहीं है ना? GA5 list नहीं है ना? GA2 तो है. नहीं GA2 किसका है?
ECI. GA2 is by the ECI.
GA2 and GA?
He only got the matter fixed at 2. He said that I will come physically to argue now. He is absent.
Okay, no problem. So I am fixing the case for argument, and your application will be taken up for hearing along with.
Lord, I understand my learned friend will not use any opposition to my GA.
No, we do not intend to. It's a point of law, my lord. It's a point of law.
I will record this. No, but here is the, let us see.
Yes.
Counsel for the respective parties are present. Full stop. The counsel for the returning officer submit that they will not cross-examine the plaintiff witness, petitioner witness. Accordingly, cross-examination of plaintiff petitioner witness is closed. Full stop. Counsel for the petitioner submit that he will not adduce any further evidence. Full stop. The respondents also submitted they will not use any evidence. Accordingly, evidence from the side of the respondents are also closed. The respondent number 6, 5 and 6.
5 and 6.
The respondent number 5 and 6.
No.
15 and 16.
15 and
for the 16. Only 16.
No,
Election Commissioner?
1 by 15, 1 by 16.
16. You are 16.
I'm 16.
The respondent number 15 and 16 have filed an application being GA2 of 2025 and GA
1. GA1
GA कौन सा है?
GA1 and
GA1 and GA2. GA1 of 2025 and
the real party has come now.
Of 2025 for deletion of their
heavy counsel also
from the instant case. So this court finds that the matter is to be fixed for final argument. Thus, both the applications filed by the respondent number 15 and 16 will be taken up for hearing along with the final argument of the present.
It's essentially a point of law, question of law, we'll argue on the question of law.
GA1 and 2 both. Present application.
You're appearing in
as,
GA1 also?
as the counsel for the petitioner is not intending to file any affidavit. Let the matter appear on. Time है कितना बजे 29th July at 2 p.m.
29th July.
2 p.m. for argument.
Grateful to
and hearing of the applications GA1 and GA2.
Grateful to your lordship.
Thank you.
Sir, 2 p.m.
With your lordship's leave.
Thank you. Thank you. Thank you. ये अच्छी है।
Yes.
Your petition, sorry.
This is my application for restitution. My lord, will recall Mr. Chaudhary was leading me the restitution application. But we are supposed to rejoin. Mr. Mitra has made his submission.
Give me 10 minutes before, because he wants some time today, because there have been some subsequent developments I may have to bring to my lord's notice. So whenever lordship fixes it, I've told him I will take 10 minutes. And also there's a huge gap between.
That's why I'm telling.
So I have to 15 minutes.
Let it be next Friday. Next Friday, my lord. Because my lord, Mr. Mitra may make his submission next Friday. We'll reply the following Friday.
Time fix हो सकता है। नहीं है।
Earliest possible.
How much time will take?
My lord, Mr. Mitra will take 10 minutes. We'll take 30 minutes. So.
It will go.
Second half ही
3 बजे 3 बजे कोई मैटर रखा है ना? 1 बजे नहीं 12:30 का मैटर होगा तो 28 अगस्त क्या है? 11:30 खाली है, हाँ? 28 अगस्त 11:30
28 क्या लिखा? 11:30
No difficulty, my lord.
But Mr. Mitra,
August. Yes.
28th August.
Yes. Yes.
As per the prayer made by the counsel for the parties, let the matter appear on 28th August at 11:30.
I'm deeply obliged.
For hearing of GF4 of 2023.
I am appearing on behalf of the petitioner plaintiff, my lord.
Yes.
Defendant is unrepresented. He has a history of not representing.
You are appearing for plaintiff.
Plaintiff.
Yes. What is the application for?
Application is for attachment, injunction, and etc.
Attachment.
Your lordship, I am appearing for the defendant. Can you give us a passover for 15 minutes? I'm led by Advocate Promit Bag.
Huh?
I'm led by Advocate Promit Bag.
Huh. Who?
Promit Bag.
Pronit Bag. Yes.
My lord, he has a history of not representing.
He want passover. What is the
No
submission?
problem.
No problem.
No problem.
Passover.
Well, I appear. Respond.
Your lordship, I appear for the defendant number 2.
I appear for the plaintiff respondent, my lord.
Yes.
The respondent has filed an application under Order 7, Rule 11, my lord. Their submission is over. We were supposed to give a reply, my lord. If your lordship will kindly take
You
the
are appearing
application
for
the plaintiff, my lord. Now, my lord, the plaintiff, the defendant number 2 has filed this application, my lord, stating that the subject matter of the property, my lord, it comes under the West Bengal Thika Act. So they want a determination under Order 7, Rule 11, whether this is a Thika property or this is not a Thika property, which cannot be allowed in an application under Order 7, Rule 11. Your lordship, I'll just give 3 dates. Writ of summons was served on 18th August 2022. Till date, they have not filed any written statement, my lord. Defendant number 1 entered appearance on 2/9/2022.
18th August?
18th August 2022.
It was served.
Yes, writ of summons was served.
2022.
22, my lord.
Yes.
Defendant number 1 entered appearance on 2/9/22. Defendant number 2 entered appearance on 3/11/2022. Written statement not filed till date.
Not even applied
Yes.
for extension.
They have not even applied for extension of time.
Yes.
Now, my lord, the matter came under the board of undefended on 20th March 2022.
20 March
2022. Then they filed this application.
22.
22, my lord.
Achha, that was 21.
Yes, that was 21. No, my lord, that was also my lord,
Oh.
23. I'm sorry. This is 23.
20th March
2023, my lord. Then they come up with this application.
Undefended.
Undefended, my lord. Then they come up with this application under Order 7, Rule 11, my lord. My case is very simple, my lord.
I had given this property, subject matter of the properties at Park Street, my lord. This property is at Park Street.
GA1.
My lord, this is GA1.
Yes.
I had given this property to the defendant number 1. Defendant number 1, my lord, thereafter, after the commencement of the Thika Act, my lord, he started paying rent, my lord, without prejudice to rights and contentions before the Thika controller, my lord. The property has not been determined to be a Thika property. Now, defendant number 1 gave away this property to defendant number 2.
This case is not decided.
No, my lord, it is. That has been that is exactly my point. Whether under Order 7 Rule 11, this point whether the property is a Thika property or not cannot be decided. My case is the defendant number 1, who is my lord Bharat Petroleum, claims this property to be a Thika property. I say this is an illegal assertion by them. Cannot be, my lord. Defendant number 1 does not come in, does not file a written statement. No Order 7 Rule 11. Defendant number 2, taking the purported case of defendant number 1, has filed this application. Now I will place this application.
Who has filed this application?
Defendant number 2.
Not 1.
No, my lord. And defendant number 1 has given this property to
I'm a sublessee. I'm sublessee under defendant number 1.
I do not recognize them, my lord, whatever their relation may be. So defendant number 1 has given the property to defendant number 2 and gone away. There is no document to show that they are sublessee here, my lord. Lease has to be by way of a registered document. There is nothing. They have not annexed anything in the application. Now, if your lordship will kindly take, my lord, their application, I'll just show 5 paragraphs. What case are they running in this application? Lordship will kindly take, my lord, paragraph 2 at page 3 of this application. May I place this, my lord?
Yes.
The defendant number 1 is a government of India undertaking involved inter alia in the business of petroleum. The defendant number 1 is a Thika tenant within the meaning of the Calcutta Thika Tenancy Acquisition and Regulation Act 1981, here and after referred to as the said Act, in respect of the premises number 87 Park Street, Kolkata 7,16,000. The sued property land comprises of a petrol pump which was constructed by the defendant number 1 thereat in its capacity as a Thika tenant thereof. Well, pausing here for a moment, this is not coming from the defendant number 1, this is coming from the defendant number 2. Well, absurd. Well, they can't run a case which the defendant number 1 himself is not running. Yes. Now, if your lordship kindly goes to paragraph 5, at page 5. Sorry, my lord, it is at page 4, paragraph 5. Further, the defendant number 1 is a Thika tenant in respect of the suit property had also preferred a writ petition before the Honorable High Court at Calcutta being WP number such and such, inter alia seeking leave to deposit its rent as Thika tenant of the suit property before the Honorable Court. Vide an order dated 5th January 1990 passed in the writ petition, the Honorable High Court allowed the defendant number 1 to deposit rent with the Registrar Original Side High Court, Calcutta. It was further clarified that such order was without prejudice to the rights and contentions of the parties. Now, if your lordship kindly takes paragraph 8.
No,
my lord.
Bharat Petroleum Institute of Bengal is seeking leave to deposit their Thika property before the 1990. The writ petition of the Honorable Court was allowed to deposit the rent. High Court
before the registrar.
Clarify, okay.
And without prejudice to the rights and contentions of the parties, my lord. Now, my lord, defendant number 1. So, defendant number 2 is trying to run a case for defendant number 1, which defendant number 1 has not come before lordship to argue, my lord. Now, if your lordship kindly takes paragraph 8 at page 6. Wide dispensing pump and selling license agreement dated 29th April 2019, and the defendant number 1 had let out the suit property including the entire petrol pump infrastructure thereon unto the defendant number 2 for a period of 15 years with effect from 29th April 2019, subject to further renewals of 5 years at a time. The petitioner crave leave to rely upon the copy of the dispensing pump and selling license agreement dated 29th April 2019 at the time of hearing if necessary. Now, one more paragraph at paragraph, my lord, if your lordship kindly takes paragraph 9, I'll just continue with this. At the time of executing the said agreement, it was assured. Now, there's a dispute between 2 and 1, my lord. That is why 1 has not come. Now, 2 is, 1 has left, 2, that you defend yourself. It was assured and represented by the defendant number 1 to the defendant number 2 that the defendant number 1 was the Thika tenant under the said act in respect of the suit property and had constructed the entire petrol pump thereon pursuant to a aforesaid sanction plan. The details of the Thika tenancy, including the information about the aforesaid writ petition and the aforesaid order of the controller under the said act, were also provided to the defendant number 2 by the defendant number 1. The pleadings in the foregoing paragraphs pertaining to the Thika tenancy of the defendant number 1 in respect of the suit property is based upon the information and documents made available to the defendant number 1 upon the basis whereof the defendant number 2 entered into the said agreement with the defendant number 1. Well, paragraph 10. The defendant number 1 is the Thika tenant in respect of the suit property. The fact has been acknowledged and declared by the controller under the said act as aforesaid. The question on whether the defendant number 1 is a Thika tenant in respect of the suit property or not cannot be adjudicated any further, and more particularly by this honorable court. So, my lord, this is the sum and substance of the argument. They say it's a Thika property. My lord, now order 7 rule 11 from my plaint, what they have showed is, my lord, I have made an averment. If your lordship will kindly take page 23, my plaint begins, and paragraph 6 at page 27.
Of the plaint?
Of the plaint. Well, of this application. Of it is annexed at page para 6 at page 27. Well, in my plaint, nowhere have I admitted that this is a Thika property. Had I admitted that, then admittedly, my lord, this would have come under the purview of order 7 rule 11. Paragraph 6. Sometime in 1981, after the promulgation of Calcutta Thika Tenancy Acquisition and Regulation Act 1981, the defendant number 1 wrongfully and illegally claimed to be a Thika tenant in respect of the suit premises. The defendant number 1 also filed a writ petition before the Honorable High Court, being WP number such and such, inter alia praying for an order seeking leave to deposit the rent before this Honorable Court. But I am myself challenging the case of the defendant number 1 that you are claiming to be a Thika tenant, you are not.
What has happened to the writ petition?
My lord, that is still pending, my lord. That is still pending. And this is without prejudice to the rights and contentions of the parties. My lord, now this is the sum and substance of this application, my lord. Now this application, whether my property comes within the purview of Thika property or not, cannot be adjudicated under order 7 rule 11. They have not filed the written statement, my lord. Defendant number 1 does not come to say, my lord, the most important document, my lord, the pleading is the written statement. Whether defendant number 1 will take this point or not, first that has to be seen, my lord. And defendant number 2 is trying to ride on the defendant number 1, saying this is a Thika property. This is, my lord, this is the sum and substance of the entire matter, my lord. Now, my lord. Yes. And my pleadings against the defendant number 2, my lord. I'll just show that, my lord. If your lordship will kindly take paragraph 2 at page 25. The defendant number 2, a partnership concern is a dealer under the defendant number 1.
Where from you are reading?
My lord, from this application, page 25. The plaint is annexed, my lord.
Yes, 25.
25. Paragraph 2, my lord. The defendant number 2, a partnership concern is a dealer under the defendant number 1 and is running the petrol pump at the suit property. The plaintiff is unaware about the constituents, partners of the defendant number 2. And my lord, if your lordship will kindly take paragraph 8, which is at page 28. The defendants are occupying the suit premises in the said property wrongfully and illegally and without any right, title and authority. The defendants are mere trespassers in the suit property. There is no dual relationship between the plaintiff and the defendants. The defendants are not entitled to remain in possession and are liable to be evicted from the suit property. Now, my lord, at the time of argument, they also argued that this is a commercial dispute. Now, the moment, my lord, they take this point of Thika, so the ownership of the land, according to them, vests in the government. Section 4 of the Thika Act, my lord. So the moment that happens, my lord, there is no agreement. There is no dispute arising out of any agreement. They're also not saying anything. And my lord, therefore, this cannot come within the commercial disputes, my lord. And secondly, my lord, they have said, my lord, one argument was made that this is not maintainable because this is not a registered firm, defendant number 2, and all partners have not been made a party. My lord, that bar under 69.
But the premises is used for the exclusively for the petrol pump?
My lord, that is by a trespasser. My lord, there's a distinction here, my lord. My suit is not based on 106. A suit against a trespasser, my lord, because...
But it is covered under the 12. Only see the, if it is...
Yes.
2C.
My lord, 2C says agreement arising out. A dispute arising out of an agreement.
Correct.
Now, the moment he says this property does not belong to me, he is challenging my title.
But you are asking for the property in
My lord.
which the petrol pump is being run by the defendant.
Yes, obliged. And
the defendant number 2 is also a party.
My lord, he's a party.
And it is admitted that there is a petrol pump.
Yes.
So it is admittedly it is being used exclusively for the purpose of the commercial
my lord,
purpose.
I'm obliged, my lord. I will answer to this, my lord. Even if a commercial property is being used as a commercial property, but what we have to see is, my lord, subject to correction, my lord, whether this is used by a trespasser or by a person under me, under my consent, under dispute has arisen. Here, my lord, any property, otherwise any suit, any commercial property in which a trespasser is involved will come under the Commercial Disputes Act. And the section clearly says, agreement arising out, the dispute must arise out of an agreement. He does not even recognize me as the owner of the property. He says, you are not the owner. I do not recognize you. So there's no agreement between us, my lord. First, my lord, may I just place the section once, my lord? The dispute must arise of the arise out of the agreement, my lord. Yes. My lord, commercial dispute means a dispute arising out of agreements relating to immovable property. Here the dispute is, he says you are not the owner. I am merely suing on the basis of my title. Had there been a jural relationship that yes, there is an agreement, you are my landlord, but because of this dispute, I will not vacate, it would have been understood. Because any case against a trespasser will not come within the purview of the Commercial Courts Act because there's no agreement, my lord. And he's challenging my title here. So there's no agreement.
He did not plead any agreement. The application did not plead any agreement.
And that is not his case. He's not run this case. Because the moment he runs this case, this entire story of Thika will go away.
An explanation?
My lord, if the section is not applicable, my lord.
Come to the
yes. Explanation, my lord. A commercial dispute shall not cease to be a commercial dispute merely because it involves action for recovery of immovable property or for realization of money or out of immovable properties given as security or involves any other relief pertaining to the immovable property. My lord, before this section, your lordship
or involved any other relief pertaining to the immovable property.
Yes, my lord, but
So
there has to be
your case is the ejectment.
My lord, my case may be of ejectment, but what is to be seen, my lord, with deepest of respect is what is the status of the party. If, my lord, if there's any commercial property, but there is no agreement between the parties or there's no dispute arising out of this agreement. Otherwise, my lord, every suit against a trespasser in respect of a commercial dispute, in respect of a commercial property will come within the purview of Commercial Disputes Act. So, my lord, the wordings which is given initially, my lord, if your lordship will kindly see, agreements relating to immovable property. My lord, there must be an agreement first. So his entire case is that this is a Thika property. He does not recognize my title. There is no question of any agreement then. So if there's no question of any agreement, my lord, there is no question of this application of this act, my lord. And he knows it. That is why, my lord, because if your lordship will kindly see section 4 of the Thika Thika Tenancy Act, my lord, the moment a party claims any property to be a Thika property, my lord, my lord, may I will hand over this, my lord. It is clear in the act. Well, may I just read? I'll hand it to. I'm sorry, my lord. My lord, may I just read?
Yes.
Section 4. Lands comprised in Thika tenancies and other land, etc. to vest in state. With effect from 18th day of January 1982, the following lands, along with the interest of landlords therein, shall be deemed to have vested in state, free from all encumbrances. A Thika land. And that is why they say that the suit is not maintainable because this is a Thika land. So there's no question of any commercial dispute. There's no agreement. Section 4, my lord. So when he is raising an issue, purported point that the land is a Thika land, first of all, that cannot be a subject matter of an Order 7, Rule 11.
That is different.
Yes, my lord. Now, so his entire point, whether this property falls within Thika or not, my lord, cannot be adjudicated here, my lord. These are my humble submission, my lord. There is nothing else in the matter. Okay. And this matter is appearing under the heading undefended, my lord, as on date.
Yes, madam.
Your lordship, learned senior counsel Honorable Ray is appearing in this matter. He has requested if it could be Honorable Ray. If it could be fixed for 1st of August or 2 p.m. to reply.
Saturday working day कब है? कौन सा Saturday working? 2nd August. 6th on 2nd August.
My lord, obliged.
Counsel for the plaintiff concluded his argument. Counsel for the plaintiff concluded his argument in connection with GA1 of 2023. Police counsel for the defendant pressed for time to give reply. Let the matter appear on 2nd August.
Only one thing I'll clarify, my lord, your lordship judgment of T. Thompson, my lord. That case arose in the facts, my lord, a notice was issued under 106. In my case, my lord, there is no notice of 106.
No notice.
Yes, my lord.
Why that is the question there.
My lord.
That was the question there. If no agreement and properties of the commercial.
My lord, there was an agreement and it was a month-to-month tenancy. Notice was issued under 106.
Correct.
Here he is denying my title. So my lord, there cannot be any cause of any agreement. He says you are not the landlord. The issue is very different here, my lord. And defendant number 1 is not saying, my lord. Defendant number 2, who has no right to raise these issues.
Okay.
Grateful, my lord.
Next.
My lord, this is my application, my lord. I was led by Mr. Bikar Ranjan Bhattacharya. Most probably he is in.
This application can be disposed of directing the receiver to supervise the constitution of the body for the purpose of mental well-being. That was my lord's order initially. Therefore, let that process be completed by the learned receiver within a certain time frame. That's all.
Mr. Bose.
Yes, my lord.
I
have no objection. Only one indulgence, my lord. If your lordship sees their prayer B, there is already a special officer appointed by your lordship, my lord. Let that special officer, in accordance with the West Bengal Societies Registration Act, conclude the process of formation of association.
Yes.
That's all that I'm saying.
It should be under the Apartment Ownership Act or the Cooperative Act. That remains an issue, but apartment ownership would be appropriate law.
It is commercial, so it cannot be under the Apartment Ownership Act. So it has to be West Bengal Societies Registration Act.
Let it be completed.
Complete.
So let the special officer see.
Yes. Let the special officer take a call and complete it at a certain time so that the entire dispute stands over.
In fact, your lordship sees your lordship's order. This was our contention and they objected. This is the order of your lordship at 22nd of January.
Now I don't object, Mr. Bose. I don't agree with you.
Yes, of course. Mr. Bhattacharya, I agree.
According to prayer B, my lord, under Apartment Ownership Act, it can be formed.
No, but Mr. Banerjee is saying doesn't make Apartment Ownership Act, doesn't apply.
No, if it doesn't apply, then Cooperative Act. If it applies, then
this is commercial. In commercial, it doesn't apply. It has to be West Bengal West Bengal Cooperative Societies Act.
I have a book with me. I can show.
Well, let it be checked by the special officer with the competent authorities and do it. Let
it check, and within a time-bound period, my lord, 4 months, that will be complete.
No, because you see, I'll tell your lordship the difficulty in time-bound. The registration does not depend on the special officer on us. It depends on authorities.
Correct.
Again, we'll come back 10 times before your lordship.
No,
not
let the
contempt,
election and other things be completed. The registration, if time takes, we shall come before the court and also pray for the extension.
No, because the previous minutes of the meeting, the parties unanimously agreed. That is recorded in your lordship's order of 22nd of January 2024. The only person who objected is Mr. Bhattacharya's client. Now, since he agrees, the question of anybody objecting does not arise. So all the special officer needs to do is, take
steps to complete the process.
Follow the procedure and get it registered.
Yes.
To the competent authorities which they apply, my lord, if there is a order at least for 4 months or 6 months, it will be easier for the formation because it's the government authorities. You have to apply before the register. If there is an order of the court, my lord, they will expedite the process. Only this.
There will be a tentative time period.
Government apartment ownership, you have to apply before the register, all the owners.
Again, Apartment Ownership Act does not apply.
Within 4 months or 6 months, anything, then it will be easier to represent the government.
The defendant number 1 has filed the present application, being GA8 of 2024, praying for a direction upon the special officer for taking appropriate steps for formation of an association in respect of the suit property in time-bound manner so that the administration and maintenance of the suit property can be managed by the newly formed association.
Yes.
Learned counsel for the plaintiff also does not raise any objection. if a direction is passed for formation of association in
My lord,
presence
one interruption, my lord. Would it be your lordship pleasure once to record this? If your lordship looks at page 21, which is the previous order of which they seek modification, my lord, internal page 4 of the of that order, which is running page 21. My lord, kindly see.
Yes, sir, last paragraph.
Last paragraph, where, my lord, it is recorded that nobody has any objection. That is the minutes. And my lord, kindly record that they are the only one who had objection. Now they have no objection. They are flat for modification. That's why appointed.
By an order dated 22nd of January 2024, considering the submission made by the counsel for the respective parties, this court recorded that the trust has no objection for formation of an association or for appointment of a special officer for maintenance of the property. Now the defendant number 1 has filed the present application for modification of the said order. All full stop. At present, all the parties have agreed for association of an association.
Formation of an association.
Formation of association. This court finds that the formation of association is to be done in presence of the special officer appointed by this court.
Yes.
All the parties are directed to give their intention for formation of association to the special officer within a period of 2 weeks from date.
Yes.
And if a request is received by the special officer for formation of association by the members, the special officer shall take appropriate steps for formation of association in accordance with law, and to register the memorandum of association within a period of 8 weeks. 8 weeks.
Very well.
8 weeks from the date of receipt of the request from the London from the all members of the society, members of the trust or society. It is
It's not a society yet, my lord.
My lord, the parties.
Lordship,
all the parties.
Of the contesting parties, that would do.
or my lord, the occupants or the owners. Occupants
করতে যাব না অনেক ঝামেলা হবে contestant বললেই হবে
of the premises.
Everybody is not contesting.
As occupants of the premises in question. In view of by this direction, GA 8 of 2024 is disposed of. The special officer is directed to file the report before this court within 10 weeks.
My lord, leave of Mr. Bose, my lord, if the special officer's remuneration, my lord, I am told on instructions because earlier the remuneration
has to be paid.
We are paying, he is getting 30,000 rupees.
Yes, but now
for the maintenance of the building.
For this purpose,
yes, absolutely.
As this court has assigned the work to the special officer for completion of the registration of the association, and thus all the occupants of the premises in question shall give the remuneration to the for the purpose of this pay the remuneration of rupees. How much?
My lord, he is getting 30,000 rupees per month for the maintenance.
That is for this.
Your lordship, these are 50,000 or
No,
something.
my lord, kindly take it from Mr. Banerjee because he is the one who's going to come and object.
I don't want to object.
50,000?
Yes, very well.
Which is okay.
Yes, to be shared by the occupants.
No, all the occupants shall give 50,000.
Yes.
No, my lord, all put together.
50,000 total would have to be shared by the occupants.
Rupees 50,000 by all the
to be shared by
all occupants.
Be shared by all occupants of the premises in
Grateful.
This remuneration only for the purpose of registration of the association.
The
remuneration fixed by this court for the purpose of other work is not included in this remuneration.
Grateful.
May it please your lordship, my lord. This is my application, Mr. I am for the plaintiff.
But here, see that applications are disposed of.
Yes, my lord.
But now I have to release this. This court is not having the determination.
But only one aspect, my lord. I must apprise your lordship that the two doors, wooden flush doors, in front of both the lift fascias have been installed. However, we had to give notices of contempt, but still it has been done. And of course, by your lordship's my lord, order. But your lordship had called for, my lord, some reports. We only need to inquire, my lord, whether those
Anybody
reports
is
have been
appearing for?
filed or not.
Let it be go to the other bench. All the reports will be there.
Yes, as on date, my lord, passing any order would
It is not good.
be difficult.
Because that I have passed because that time it is a part-head matter. No, this is not a part-head.
But my lord, one correction, my lord. GA6, my lord, was also part-head.
No, that's why the GA6 I not disposed of because all the things is required.
But GA6, my lord, continues to be part-head.
Where is the order?
It was, my lord, in the same order.
Where is the order?
GA6 is, as I know, my lord, was part-head.
order है क्या GA6 का?
Yes, please check.
Huh?
My lord, CAV means your lordship had kept all the matters for CAV. That correctly, your lordship, my lord, has disposed all the matters, including GA7, excepting GA5.
What is the GA6?
GA6, my lord, is the application where your lordship has called upon for reports whether, my lord, the building stands properly through sanctioned plans from the KMC, also report from the fire department.
Anybody is appearing today?
Or whether they have
Any
filed
notice
any
was
report.
issued?
Yes, your lordship, my
Where is
lord,
the
the court is supposed to issue the notice.
No.
And even we have given them.
There is a direction.
Yes.
I don't know if it's part-heard, but
Only CAV I fixed.
from the page 16 of the last order, I see some GAs were disposed of.
Yes, 2 GA disposed of, 6 was
Six
listed
was
for
to be listed on
today.
25th of July.
Yes.
Because it was fixed for CAV.
Lord, we have issued them notice, my lord. Plaintiff is directed to issue notice upon the authorities.
Where is the notice? Okay, I am releasing, you mentioned before.
Very well. We have notified them. We'll file it through an affidavit.
This court find that this court is not having determination. Accordingly, CS 254 of 2021 along with connected pending application is released from the list of this court. Liberty to mention before the appropriate court. Liberty to mention to the parties to mention before the appropriate court.
Deeply obliged and thankful. The gates are now there. The gates are now there. Deeply obliged.
That is law. The court can't do. That is as per law.
Yes.
9, my lord, I appear for the defendant number 1.
My lord, I appear, my lord, virtually, my lord, for the petitioner. My lord, although the main suit is no longer in your lordship's list because of, my lord, determination being changed, but this is, my lord, an application for modification and or clarification. Very innocuous prayer, my lord.
Of my order? Of
your lordship's order. My lord had permitted, kindly comes to the order at page, my lord, 146, volume 2.
143.
146, my lord.
146.
Yes, my lord. The order starts at 146. Lordship kindly comes to, my lord, paragraph 13, which is at page 148.
Yes.
Though by the order dated 19th March, this court refused to allow the defendant number 1 to pay the monthly salary of the employees of the trust by modifying the order of 9 January 25, but considering the submissions made by the counsel for the defendant number 1, that defendant number 1 will also pay salary of the employees and Purohit of the trust, this court allows defendant number 1 for the present to pay salaries of the employees as well as Purohit of the trust of his own fund and keep proper accounts. Adjustment of salary of employees and Purohit, if any paid by the defendant, shall be decided at the time of hearing of injunction application. Our contention was, my lord, initially there is a previous order of your lordship. Kindly takes page 144.
Yes.
Kindly comes to, my lord, paragraph 6 at page 144. Counsel for the defendant submits that due to the interim order passed by the court, defendants are not in a position to pay electricity bills as well as salary of employees, and accordingly he prays for modification of the order by allowing the defendant to pay the monthly electricity consumption charges and monthly salary of the employees of the trust. Well, this order was passed on the application which they had filed. Now, after that, para 7 records our submission. We disputed with regard to the salary of employees of the trust, but submits that as regards payment of electricity consumption charges, plaintiff is regularly paying the same. Today, my lord, our contention is that these two, my lord, employees, one is, my lord, the caretaker and one is a Vyavasthapak. My lord, this is in respect of a trust property at Rajasthan. Lordship had passed initially on 9 January an interim order in my favor. They are seeking modification of, they have sought for modification to the extent that they can pay these 2%. Our contention is they have been wrongly employed or illegally appointed by the defendant. So any payments made by the defendant to these persons, they will not claim any right or any equity in respect of this. And I have filed, my lord, an amendment application in the suit, my lord, specifically taking this a ground. If your lordship kindly once takes, my lord,
Page 101 onwards.
At 121, if your lordship kindly comes, this is the, my lord, pleading in the, my lord, amended plaint. I straight away take your lordship to the relevant portion. It starts at 101. I am referring to page 121, subpara R and subpara S.
Yes.
The defendant number 1 purported to appoint one Niranjan Dev Sharma as Vyavasthapak of the trust on or about 1st January, although the document relied upon in support of such alleged appointment is dated 8th of January 25 and notarized on 10th January. The defendant number 1 is purported to appoint one Kailash Devi as caretaker of the trust on or about 4th January without the consent or approval of any other trustee, and to the violation of the trust deed dated 29 June. By the, as modified by the supplementary trust deed dated 16 September 19, no document in support of such alleged appointment has been disclosed by the defendant number 1 in the application being IAGA number 3 of 2025. So my challenge is there, my lord. There is also, my lord, my opposition to his application where this stand is there. There is, my lord, kindly comes to page 165 once. Defendant number 1 had filed an application being IAGA 4. They wanted vacating of your lordship's interim order of 9th of January, in which lordship had permitted us to use affidavit. In that affidavit, we had also taken, it's not that I am taking it for the first time. Page 165, my lord, just leaving first 7 lines. At the top, the purported appointment of Niranjan Dev Sharma as Vyavasthapak and Kailashi Devi as caretaker are both unilateral, fraudulent, wrongful decisions taken by defendant number 1 to the exclusion and behind the back of all other trustees. The same are not decisions of the trust. The defendant number 1 purported to appoint one Niranjan Dev Sharma as Vyavasthapak of the trust on or about 1st January. The document relied upon in support of such alleged appointment is a manufactured and concocted document. No reliance can be placed upon it. Defendant number 1 purported to appoint one Kailashi Devi as caretaker of the trust on or about 4th January without consent or approval of other trustees and in violation of the trust deed dated such and such as modified by the supplementary trust deed dated such and such. No document in support of such alleged appointment has been disclosed by the defendant number 1. So this is my stand with regard to these 2 persons. Now kindly sees my prayer, my lord, in the, my lord, application. Kindly comes to paragraph 8 of my application. Paragraph 8 at page 7 of my application.
Yes.
The plaintiff states and submits that the order dated 27th March is required to be modified or clarified. I'm sorry.
Paragraph 8.
Paragraph 8 at page 7 of my application. Plaintiff states and submits that the order dated 27th March 25 is required to be modified or clarified so as to indicate that purported payments, if made by the defendant number 1 pursuant to the order dated 27th March, would be made without prejudice to the plaintiff's rights and contentions in respect of the validity of the purported appointments of Niranjan Dev Sharma, Hari Bhagwan Maharshi and the caretaker. It is further required to be clarified that the order dated 27th March does not in any manner recognize or validate the appointments of Niranjan, those 3 persons, legality whereof is under challenge and are to be adjudicated at the final hearing. So this is, my lord, the prayer I am seeking. If your lordship now takes prayer A of my application at page 8.
Yes.
There's one typographical error I must indicate. It should be para 8, my lord, in that prayer, not para 5. The order dated 27th March 25 being annexures D here to be modified and or clarified to the extent as stated in paragraph, it should have been 8, my lord, 8 here in above. So what I am seeking is, my lord, only a clarification that let them go on making payment. But these payments will not really change the situation because I have put this under challenge. There is not only an opposition filed which is on record, but also an amendment application where, my lord,
Amendment is allowed now.
no, it's pending, my lord. It was taken up last week and it has been again fixed on 31st of July. There's a demurrer from their end and an amendment application from my end. Both applications are to be heard together. Now, my lord,
Let the first amendment be allowed, disposed of.
my lord, this no prejudice would be caused even if this is allowed today. Why I say this? Because if today lordship clarify, I'm not saying that lordship injuncts them from making the payment. Let them go on making payment. But subject to the result of the amendment, lordship may provide for this. Subject to the outcome of the amendment, till such time, any payments which they are making will abide by the, my lord, conditions which I've indicated in paragraph 8. Kindly takes, my lord, only 2 stand they have taken in the opposition since it's after affidavits. My lord takes the opposition ones which they have filed.
The GA number is wrong.
If you have opposition to this application.
My lord kindly comes to page 4, paragraph 7.
GA numbering was different.
You've mentioned the right GA, G7 you mentioned.
Third line, it is denied that the plaintiff in his plaint and the various applications filed before this court has challenged the purported appointments of such and such purportedly appointed by defendant number 1. My lord, I showed the amendment application. I showed the, my lord, affidavit in opposition to their GA4, which is a vacating application. So this denial statement is, my lord, on the face of it, incorrect. Then para 8, my lord. Kindly sees para 8, last 3 lines.
Yes.
It is denied that the defendant number 1 will use the order dated 27th March 2025 to contend that the employees purported to have been appointed by the defendant number 1 have been recognized by the Honorable Court as employee of the trust as alleged orator. So this, my lord, again, my lord, that they are denying. I don't know what is, my lord, the purpose of this denial, and this assumes significance in view of the stand I have taken in the application. And last is para 12, my lord, at page, my lord, 6.
Yes.
These are the only 3 points they have really, my lord, taken in the opposition. I state that the order was passed in the presence of the plaintiff, and upon contest, plaintiff under the garb of the application is seeking to prefer remedy under the appeal, which is impermissible in law. My lord remembers when the initial order was passed, where lordship had directed affidavits to be exchanged, lordship refused them this prayer. They mentioned the matter, brought it under the heading to be mentioned, saying that there is Hanuman Jayanti, we need urgent orders, we need to pay the employees, the caretaker, the Vyavasthapak, without which, my lord, the Hanuman Jayanti could not be organized. Considering that, lordship was kind enough to, my lord, clarify that let them make this payment. So what I am seeking is only this, let them still continue making payment. But subject to, my lord, what I have indicated in para 8, this should not prejudice any party, my lord, to the suit.
Yes.
But first of all, my lord, the suit, my lord, everything is being heard, my lord, before the other bench, my lord. We have filed an application under Order 7, Rule 11, and we are seriously opposing the amendment application, my lord. I believe if, my lord, any of the prayers granted in this application will prejudice our Order 7, Rule 11 as well as the amendment.
No, only they're telling that this order is without prejudice, right and contention of
Your lordship, let this matter go before the regular bench, my lord, because everything.
They want the my order, they want a modification. How the other bench will take
Lord, in that case, my lord, the Order 7, Rule 11, where we are, Lord, seeking to revoke the leave, my lord, then we have to get that application heard before this bench, my lord.
No, not that.
Lord, this order, my lord, I believe, my lord, this application is, my lord, is not, my lord, maintainable because the prayer A seeks, my lord, modification of the order dated 7.
No, only I will say this order has been passed on without
Your lordship, I kindly don't say. Your lordship, I kindly releases the matter. Let it be placed before the regular division.
Record an order. Counsel for the defendant is not interested to do the matter before this court. Accordingly, the matter is released for
I'm
the
not
list of
saying,
this
Lord,
court.
because everything is being heard before that bench, your lordship.
Yes, call the matter.
My lord, I'm sorry for the interjection, my lord, but lordship was very right when lordship said
Counsel for the defendant is not having a trust over this court.
Your lordship,
Accordingly, on the prayer made by the counsel for the defendant, the matter is released from the list of this.
Your lordship, I kindly do not record
Yes,
that.
call
Lord.
the
I'm
matter.
sorry. It was not that intention, Lord. Everything is being heard before that bench.
Before making submission, please consult the seniors. What submission is to be made?
I'm sorry.
Yes.
My lord, this is, my lord, a contempt petition. My lord was pleased to pass an order, my lord, on 7th July.
Contempt.
Yes, my lord. My lord's order, my lord. This was, my lord, in regard to, my lord, a testamentary matter. Property, which, my lord, was pleased to, my lord, injunct. This was half share, my lord, which the testatrix had in a property, my lord, in Shillong. The my lord was pleased to, my lord, injunct it. There was also, they made an application for deletion of that property. That was not finally permitted. And, my lord, passed an order, which, my lord, and, my lord, after that, my lord, order, we also, my lord, advertised in the papers with regard to the injunction order. We also wrote to their advocates saying that don't deal with it. In spite of that, my lord, it's been dealt with. That's, my lord, what the contempt is. My lord, will kindly come to the order, my lord, pages 45 to 48.
Respondent has already filed an application for deletion of the immovable property. There is a 50% share interest of Rose. Acha, Rose Valley.
45, my lord. Yes, my lord. I don't know whether, my lord, will recall, my lord. This is page 45. Then page 45 is the number.
Yes.
Page 45, my lord, is the order.
Yes.
Of volume 1. Petitioner is trying to alienate the property which is a part of the will that is undivided.
So page 48, the operative portion.
Yes, absolutely. I'm so sorry, my lord. I didn't read. My lord has already read that, my lord.
So mean the
Parties,
parties are
yes.
directed to maintain
Status quo till the next date of hearing.
Next date of
Then, my lord, the order got, my lord,
extended.
from time to time, and now, my lord, the order has been also made absolute. So, my lord, now, my lord, kindly come to, my lord, page, my lord, just 2 more pages. My lord, 239.
239.
Volume 2. Volume 2 ta deven. Volume 2. (239), my lord. In 239A, my lord, is the typed copy. The public auction, my lord, is on the right hand side. Sorry, public caution notice. Auction. 239A, my lord, is the.
Yes.
And, my lord, will find in the middle. After hearing the parties to the suit, Honorable High Court Cal passed an interim order directing defendants and such. Order was passed on contest in presence of advocates representing defendant. Interim order was passed on July 7. Then, my lord, page 240, my lord, was a corrigendum. And then, my lord, 241, my lord, is another public caution notice, 241. My lord, this is 19th November 2024.
Yes.
This, my lord, in Shillong Times. I know they had also kept on appearing. Then, my lord, very important. My lord, kindly come to, my lord, page 242, where, my lord, presence, my lord, that was extended. Then 243.
Yes.
243, my lord, this is to the advocates. From our advocates saying that please note that until this time, my lord, it wasn't sold. Please note that the caption matter was taken off hearing today by Sansaj. Please to fix the interim order status quo in the matter till 30th January and fix the application hearing. Our client has come to learn that your client is attempting to deal with the Roseville property, which is the subject matter of the caption application despite subsistence of the interim order. Therefore, request you to advise your client to comply with the directions contained in the order dated 7 July 2023. This is my lord's order. A copy of the public caution notice dated November 19, 2024, published in Shillong Times on behalf of our client was handed over to the counsel appearing on behalf of your client in course of today's hearing. Copy of the same is again enclosed for your record and ready reference. Then, my lord, this was handed over. That's the notice, my lord, which we hand over. Then, my lord, kindly see 244. This is, my lord, as on December 12, 2024. Kindly see under instructions from our client. We write to you as under. On about December 7, 2024, our client's local advocate, Mr. Amit Sansaj, received a call reportedly from police station from mobile number when he was informed that a complaint had been lodged by one Mrs. Moitri Berry against Shormila Shetty, who's the defendant here, concerning a dispute in respect to Rosaville property situated in Sansat, Shillong. Was further requested to provide relevant document information connection to subject property. Hence, the brief background of the matter is stated below for your kind consideration. Then, my lord, we state all that, and my lord, 245. Last paragraph, our client, upon coming to know that such and such was attempting to deal with the Rosaville property in deliberate violation of the directions contained in the subsisting order, had immediately caused a public caution notice to be published in the Shillong Times newspaper November 19. Copy of the said public notice also served upon the learned advocate representing said Mrs. Sansach in the caption Probate Proceeding under cover of the letter November 26, 2004, 2024. Copy wherever is enclosed herewith for you ready. Then, my lord, we wrote to our advocates, local advocates, writes to us. That's page 246. As per your request regarding the police complaint reportedly lodged by Moitri Berry, connection with public caution notice in Meghalaya Gaj and Shillong Times on Tuesday regarding sale of Rosaville property, arranged 2 of my junior advocates to travel to Meghalaya on 21st December, gather information about the incident on the basis of a phone call received on 8th December from the number Sansach. During their visit to Nongthimal police station, my juniors were informed that a complaint was lodged by Moitri Berry. Police had informed that the telephone call received from phone such and such belongs to one of the police personnel of Nongthimal police station. However, despite repeated verbal requests, police personnel were not provided any documents related to complaint lodge. And please note that this correspondence provided solely as an update on the efforts made, any actions are there. Then, my lord, 247 is important, where, my lord, we write to, my lord, the headman of that village, because these properties, my lord, I'm told, my lord, is no formal my lord, deed or, but from the headman, my lord, because it's in that village, my lord, it's a property of, my lord, the testatrix. My lord, we wrote 50%. Because the Moitri, my lord, saw that name. She had 50%, and, my lord, this testatrix had 50%. This is the testatrix daughter, my lord, who's dealt with it. I hope this letter finds in good health, writing to formally request you to kindly provide and hand over all relevant documents and papers pertaining to the Rosaville property situated in Southern Such. It has recently come to our attention that the said property has been sold illegally, thereby violating the court order that has directed maintenance of status quo concerning the aforesaid property. Copy of the court order is enclosed. Matter raises significant concern as such an action directly contravenes the legal directives and compromises the integrity of the ongoing proceedings. To ensure that all necessary steps are taken to address this issue, we kindly request you to provide the following: any document on record related to the property, copies of agreements or permissions, if any, that have facilitated the said transactions. 3, any correspondence or communications concerning the property in question. Your cooperation in this matter is essential to uphold the rule of law and ensure justice is done. We trust in your support and such. Should you require. Then, the reply comes, page 248.
Yes.
So, my lord, I am told, my lord, this is the registering authority, my lord. That's our, my lord, information which we have received. My lord, sees at the top, my lord, will find.
Told by Maitri,
yes,
yes. Committee and Srimati Sajila
to such and such. On 14 December 2024.
After the order.
Correct.
And when the order was confirmed?
My lord, order was finally, my lord, confirmed on, my lord, 11th April 2025. The order was throughout continuing. Because that application got disposed of by confirming.
Whether this court can continue?
My lord, we went to that court, my lord, the court, my lord, sent it back. In fact, my lord, we came here, my lord, sent it back, and then again, my lord, we were sent back. We, my lord, went from here because that day, my lord, correct. I thought, my lord told us that whether, my lord, I should take it up. My lord, we went, the court said, no, it is my lord's order, so, my lord, we should be back here. Yeah, my lord, it's court, my lord, whichever, my lord, court. So, my lord, this is what we have. My lord, 247 and 248. This is, my lord.
Notice the issue.
My lord, notice, or, my lord, I was praying for rule. Very well. Let's take notice.
Because already sold. Let the notice issue.
My lord, the property is. Beneficiaries. Well, because the beneficiary is the trust. Well, very well. Well, let notice be issued. Well, we'll come back with the notice. Well, kindly make it returnable. Let's take. Because well, I think well, there's a clear case. Well, rule should be issued. But since well, it's the that's right. And well, only one thing. Well, then well, there should be no further alienation because you also made the purchaser a party. Well,
we confirm it there. Then again they will. Let the notice go. If they come, they file the affidavit of compliance. We'll see to that.
Very well. Very well. Because it's been sold, my lord. It's quite obvious, my lord, from the.
This contempt application is filed on the allegation of violation of the initial order passed by this court dated 7th July 2023, wherein this court has directed the parties to the suit to maintain status quo till the next date of hearing, and the said order of status quo was extended from time to time. Finally, the interim order was affirmed on
11th April, my lord, 2020. GS6. In GS6, my lord.
On 11th April 2026. 5. Counsel for the plaintiff petitioner has drawn the attention of this court to the document issued by Raham Chom, page 248, wherein it is certified that wherein it is stated that the Rose Valley property located at Lumbasuk dash capital A dash Lodge and View Nokitama ये देख के करना falling under the jurisdiction of Dober Shong Lorman has been sold by Matri Rosa Khamte and Srimati Sarmila Sethi to so on 14 December 2014.
We are concerned with
this court finds that before passing any coercive order.
So sorry, I'm so sorry, my lord. Only one thing, my lord. The Shormila is the one, my lord, who's the defendant in the suit. She's the one, my lord, who sold. 50% was owned by her. That's, my lord, the subject matter of the trust. My lord, only one request I'm making. Though, my lord, we have made a prayer F there. Since, my lord, the order of status quo, because anything done in violation of order of court, my lord, will be a nullity. But since, my lord, there is a order of status quo, my lord, that should be maintained. Because I don't want, my lord, further, because now the purchaser, my lord, is 2 and 3. 2. 3 is, my lord, the constituted attorney of 1.
This court, at present, this court is not. Before giving any opportunity of hearing, to the alleged contender, it is not proper for this court to pass any coercive order against the alleged contender. Accordingly, the petition is directed to issue notice upon the alleged contenders and to file the affidavit of service on the next date fixed. This court finds that even after the order of status quo passed by this court, which was duly confirmed by subsequent order, the alleged contender has sold the property, and as such, by further order of injunction, the respondents, their men, servants, and agents are further restraining for dealing with or disposing of or encumbering the said property till the next date of hearing. Let the matter appear. How soon you will serve the copy? Long
2 weeks.
Let the matter appear on 12th August.
Not 12th, I mean, 12th, I mean, Lord, can it be, my lord, 18th or 19th, my lord?
19th August.
19th. Sorry, my lord, 18th. I'm so sorry.
18th.
I'm grateful, my lord. 19th tomorrow day. I'm grateful.
Acha, non-commercial. It is, let it know, 22nd August.
Very.
22nd.
Yes, ma'am. Affidavit of service code.
Yes, 22nd August.
First take how is what's happening? Oh, okay. 22nd. I'm grateful, ma'am.
I beg to appear for the defendant numbers 1 small ABC and 3 capital A.
Yes.
For defendant number 5A to 5C.
Defendant number 3A was on the dock. Cross-examination was going on. If your lordship kindly takes the last order, it is of
It's a parted matter. Why it before this court?
February 10, 2025 order.
Assignment.
Yes. February 10, 2025 order, if your lordship kindly takes up. There is a reason I'm trying to show this, my lord.
Which one?
February 10, 2025 order of your lordship, my lord. And my lord may kindly come to the interim page 2 last paragraph.
February.
Yes, 10th February. That is the last order.
10th February.
Last time the matter was taken up and the examination was going on then. The cross examination was going on.
कौन सा order matter दिया आप लोग?
The last paragraph. May I hand up a copy? May I hand up a copy? I have a copy. The different number 6 was not cross-examining. Copy. Different number 6 was cross-examining. The interim page 2, if your lordship kindly takes the last paragraph.
Yes. Appearing person represented cross-examine the defendant person in court but found incompetent to cross-examine the witness. According cross-examination, therefore defendant is directed to appoint an advocate. Defendant is not able to appoint any advocate for herself. She may pray before this court for.
And my lord, after this, my lord, our instructions are, lord, this order was taken up in appeal. My lord, nothing has happened there so far. And my lord, I believe Mrs. Khemka is appearing. She is the defendant number 6 in person.
Yes.
मेरी डॉटर को पावर दिया हुआ मेरा, वो थोड़ा बीमार है तो आ नहीं पाई है।
आपका डॉटर बीमार है, उस दिन कौन हुआ? आपकी डॉटर थी?
हाँ, मेरी डॉटर।
तो वो तो क्रॉस नहीं कर पा रही है ना, इसलिए मैंने कहा आप या तो वकील कीजिए, या वकील नहीं कर सकता तो आप कोर्ट में बोलिए, आपको लीगल एड से वकील दिया जाएगा। आप यहाँ खड़ा होके कोर्ट का टाइम वेस्ट कर रही हैं, अपना केस बर्बाद कर रही हैं आप।
अपील किया है।
अपील करे जो भी अपील में स्टे है नहीं है।
Not heard out. Not up in the list.
कोई नहीं है, वो बीमार बहुत हो रही है, उसका खुद का भी प्रॉब्लम चल रहा है।
तो फिर केस कितने दिन? केस काफी पुराना है, क्यों यहाँ पे रखे हैं?
डिफेंड नंबर 3A
वन का केस है, थोड़ी चल सकता है। आप अपील करिए, लेकिन यहाँ में तो आइए क्रॉस कीजिए।
When the examination commenced, we were not given any liberty, to. But if they doesn't want to continue, it may be closed.
कंटेम्प्ट भी है सर।
वो ठीक है, 5 घंटे मैंने तो ऑर्डर कर लिया है ना, मैं सबको एक साथ हियरिंग करूंगा करके। आप पहले अपना
तो सब बेच रहे हैं और भी।
तो आप अपना विटनेस लेके, आप तो अपनी टाइम, जब आपका केस
200 करोड़ की प्रॉपर्टी को इन लोग।
मैडम, जब अब अपॉर्चुनिटी मिल रहा है, आप गवाही कर नहीं रहे हैं।
नहीं, गवाही तो कर ही।
आप इंटरेस्टेड है कंटेम्प्ट में? कंटेम्प्ट में आपका प्रॉपर्टी आपके घर में थोड़ी ला के दे देंगे। आप कल केस तो प्रूव कीजिए।
350 जो डिफेंडर नंबर 3A है, उसमें पूरा।
आपकी बेटी कब आएगी बोलिए, मैं उस हिसाब से आपका डेट रखूंगा।
3 वीक का रख दीजिए सर, उसको थोड़ा बड़ा प्रॉब्लम है, ये प्रिस्क्रिप्शन है उसका।
Then the last order will be nullified if they do not.
It's lying in list. 2 and 3. Who is appearing for 2 and 3?
2 and 3. Defend number 2 and 3. Defend number 1 small ABC and 3 capital A is who I am representing.
You are appearing. Defend number 1, Mr. Mitra is appearing.
These are all substituted defendants.
Defend number 6, Neha Khemka. आपने वकील किया है, नहीं किया है?
नहीं, अभी तो नहीं।
फिर कैसे होगा आपका केस, बताइए।
क्योंकि मेरी डॉटर काफी दिन से बीमार हो रखी है।
मैडम, आप केस चलाना
बीमार रह रही है और उसका खुद का भी।
मैडम, आप केस चलाना चाहती है या नहीं चाहती है, बताइए। आप केस चलाना चाहती है कि नहीं चाहती है? तो फिर इस तरह से आप जब डेट है आप टाइम लेती है कोर्ट, में आपको तो लास्ट
टाइम लेने में हमने कभी किया, आज के पहले हमने कभी भी टाइम नहीं लिया, एकदम फर्स्ट टाइम आया।
Plaintiff is also, kindly excuse me for submitting. She is defendant number 6 in the main suit. The plaintiff as well as other defendant, they are also not much interested.
No, the cross examination going by them only.
By them. Yes, that cannot be taken. Yes.
That's why if the witness will come, first she has to complete the cross examination. Then if the other party is taking time, then the court will take appropriate.
From my learned senior friend's submission, my lord, the suit was about to be settled. It was at the verge of settlement or accident. It was on the verge of settlement.
Can the matter be sent to the mediation?
It perhaps can, not all the other parties.
सर इसमें एकदम भी पूरा बेच दिए, प्रॉपर्टी कुछ बचा ही नहीं।
अरे मैं मीडिएशन में भेजूंगा, सेटल कीजिए।
200 करोड़ की प्रॉपर्टी है सर, उसको ये लोग ने आप पहले कंडीशन के इनको वो करवाएं सर।
With my lord's kind permission, may I also submit this, my lord? It is the defendant number 6 is already, my lord, trying to, my lord, stall the settlement, and she has been offered her share also. She has been offered her share. I have also, my lord, taken out an application which is pending in the list. I took out an application to bring these facts on record, my lord. That is also in the list. I believe, my lord, this can be settled between the parties.
That we will live, nobody will interfere to the extent if she is at all entitled. But apart from her share, there are number of defendants who have sold it.
The only
Therefore,
issue,
her intention is also to prevent those from selling out and getting those shares.
The only issue was
Be entitled to
आपका
her
आपका
share.
उसमें कितना शेयर है?
मेरा 1/5 शेयर है
1/5 शेयर है ना, तो उनको तो वकील साहब 1/6 शेयर है, 1/6 शेयर है।
तो उसमें मेरा ओरिजिनल उनका ओरिजिनल पेपर
तो
आपने
कोर्ट डिसाइड करेगा, वो तो कोर्ट
पेपर वहाँ पर अभी कैसे रखा, क्योंकि जजेस स्लिप में से मेरा पेपर गायब हो गया, तो वो तो पेपर ओरिजिनल यहाँ पर
Did on our part unless he get a read with the
आप बोलिए आपकी बेटी कब आएंगे, उस हिसाब से मैं केस रखूंगा, मैं प्लेंटिफ को बोलूंगा आने के उनको who's witness, plaintiff's witness.
on the defendant number 3A.
No,
who is going on?
whose witness is on dock?
Defendant number 3A.
3A is on dock.
Saraswati Chand Bajaj. He is on dock.
आप बोलिए मैं उनका गवाही को बुलाऊंगा, उस दिन आपको क्रॉस करना है।
4 weeks टाइम दीजिए थोड़ा सा उसको
कोई
रिकवर
एक डेट दो इनका गवाही के लिए, मैं फिक्स करता हूँ टाइम, और फिक्स नहीं होगा फिर मैं क्रॉस एग्जामिनेशन क्लोज कर दूंगा।
Thank you.
एक डेट दीजिए। हाँ, 9 September 2 PM. The defendant number 6 appeared in person and submits that she has given a power of attorney to her daughter to conduct this case, but her daughter is under medical treatment, and as such she prays for 4 weeks time. In view of the submission made by the defendant number 6 in person, the case is adjourned. Let the matter appear on 9th September at 2 PM. 9 तारीख 9वां महीना 2025 2 बजे आप यहाँ आइए क्रॉस करने के।
9 महीना में डेट कौन सा सर?
9 September 9 September 2025 at 2 PM for cross examination of the defendant number 3A. 3
capital A.
3 capital. The defendant number 3 capital A is directed to appear on the date fixed for cross examination.
The contempt is also appearing together then.
I am Milad Choraria.
Item number
15.
Yes.
I am Milad Choraria, my lord.
Yes. What has happened in your Supreme Court?
Not listed now.
Listed?
Not listed.
Not listed. So what is your prayer now?
My prayer is adjourned.
So what about this case, sir?
That is the subject matter, because my lord, your lordship has passed one order on 2nd January 25 that an application praying for modification of order date and so and so and so and so. Court has found that enclosed the said orders are not enclosed. According to petitioner granted liberty to disclose the orders. That is I have disclosed. But by order date 27 August February, your lordship has denied to accept this application and sent to department. I cannot come to Calcutta because of the plaintiff wanted to kill me. That is why I am not in position to come to Calcutta and correct the position of department.
Okay, so what is your submission now? What you want now?
Now adjournment. Only solution is adjournment.
For what?
2 months time.
Why adjournment you are praying for?
Because this matter is subject matter is pending in the Supreme Court.
My lord,
Mr.
I just out of my submission is this has become like a luxury litigation. And on one hand, this such a long period, I'm appearing for defendant number 2 and they are saying
I will go out before reaching my in my chamber. I will get the 5 pages in email.
I know.
Mr. Milad Choraria appeared, defendant number 1 appeared in person through virtual mode and submitted. He filed an application. He filed an SLP before the Honorable
Not SLP, writ petition.
He filed a writ petition before the Honorable Supreme Court and prayed for 2 weeks time and 2
months time.
2 months time. In view of the submission made by the defendant number 1 in person, the case is adjourned. Let the matter appear on 12th of September 2025.
Thank you, sir. Thank you, my lord.
much of.
Application, my lord, the suit was dismissed quite a while back. My lord, this is my service affidavit. The affidavit of service. There are three defendants, three addresses of the defendant. It has been served on one address. The other two has come back. Page number 5, if your lordship kindly sees.
Yes, sir, that's fine, that's fine. Dismissed on July 2022.
Yes.
So,
Lord, I have explained in paragraphs 4 onwards why was the delay. Because
what was the suffering? The plaintiff has filed the present application being GA2 of 2025, praying for recalling of the order dated 6th July 2022, wherein this court has dismissed CS number 119 of 2018, along with all connected application for default. Police counsel for the plaintiff submits that the father of the plaintiff.
My lord, not the father of the plaintiff is a company. But my lord, one thing I will be candid.
Yes.
Candid, my lord. Possibly a section 5 was required.
Not 5.
Not, my lord, possibly a section 5
Here
was
also not so.
My lord.
Here also you're not prayed for.
Section no, my lord.
Okay,
that has not been prayed for.
Filed an application for recalling of the order, so and so. But this court find that the petitioner has filed the present application on 21st of January 2025, after the long period of dismissal of the suit. According counsel for the plaintiff prays for time for taking appropriate steps for filing an application for condonation of debt. Let the application be filed within 2 weeks. Within 2 weeks. List the matter on 22nd August 2020.
We friends are going on a trip.
29.
Well, the affidavit of service be kept.
Affidavit of service be kept with the record.
For the respondent, my lord. Circular transaction matter, your lordship remembers, my lord. No, my lord, I don't remember because last.
Pranavasut City.
Yes, my lord. Now, my lord, even I don't remember because we concluded arguments in January. Since then, my lord, they've been taking time. Now we are in end of July. If they wish to argue, let them argue, my lord. I will recapitulate for 5 minutes on the next.
I remember, but Mr. Dutt also needs to remember.
I don't know, my lord.
Requested for some time. The lordship may fix a date and time, my lord. I know it is going up to September, but if it can be accommodated prior to that, any date and time, I leave it to your lordship, my lord.
Let it appear in the list, my lord, and it will be taken.
Because Mr. Dutt, my lord, has argued at length. I should not cross that threshold and make such.
What has happened to that appeal? Your appeal? No.
Yes, my lord. Appeal was dismissed, but I was given the liberty that if my counter statement comes in, written statement comes in with counter claim, I will get addition of part.
Yes, a written statement.
Yes, so my written statement application is also filed, my lord.
So that is to be.
That is GA3.
This is judgment upon admission. It also has a prayer for judgment upon admission.
GA3, my lord, is my written statement. If that can be considered, I can argue my GA3, my lord, since the matter is taken up. Instead of.
Date kuch hai, dekho.
My lord, any date in early September also, my lord, then we can accommodate and we can, my lord, make our submissions.
This is one plaintiff who doesn't.
Reply.
One plaintiff who doesn't want a decree on admission.
अगस्त में नहीं है ना 2 डेट दे दे एक साथ खत्म कर दे I will fix 2 continuous date सितंबर में 12:30 होगा चलेगा first and second September 12:30 as per the prayer made by the counsel for the plaintiff case is adjourned. Let the matter appear on 1st September and 2nd September 2025 at 12:30 noon.
GA3 should also be in the list, my lord. I think
that is already there.
It is already there. It is already there. Deeply applied.
Your Lordship, I am appearing for the defendant. Your Lordship, my senior in this matter is Miss Anjana Banerjee. She hasn't been able to.
Who?
Miss Anjana Banerjee, Your Lordship.
My lord, I appear on behalf of the plaintiff petitioner, my lord. My lord, the GA3, my lord, filed by the defendant, my lord, revocation, my lord, that has been, my lord, heard. My lord, by the both the parties. Now, my lord, the GA1 application, that is our application, my lord, for interim reliefs, my lord. My lord, that is, my lord, we need to start, my lord. I am late by Mr. Anirban Ray, my lord. I am seeking, my lord, an accommodation, my lord.
What about the GA3?
GA3, my lord, have heard, my lord. Both the parties, my lord, have made submissions, my lord.
Your Lordship, my senior is leading me on this
That
matter.
charitable, okay.
Yes, my lord. It is a section 92 suit, my lord, filed by Yas, my lord.
Okay. Your Lordship, I am instructed to pray for an accommodation for this day. She hasn't been able to
As per the
communicate.
prayer made by the counsel for the parties. As per the prayer made by the counsel for the parties. Case is adjourned. Let the matter appear on 8th August 2020.
Deeply obliged, Your Lordship.
Yes, next.
My lord, may I? My lord, is it, my lord, 8th of August?
Yes.
My lord, in that case, my lord, my interim order, my lord, is till 5th of August, my lord.
The interim order is
My lord,
till 22nd of August 2025 or until further order, whichever is.
grateful, my lord. Grateful.
Yes, next.
Item 19, Your Lordship, I am the applicant in GA2. This is an addition of party application.
Well, I appear for the plaintiff in this matter, my lord. I'm led by Mr. Arif Ali, my lord. He's on his legs in court number 41.
My
I'm
application,
only praying,
may
my
I,
lord,
may I
kindly
just
keep it next Friday, my lord, in that case.
may I just indicate why I should be impleaded as a party? Your Lordship, kindly take GA number 2 once. That's an addition of party application. GA2 ta deben ekbar.
Yes.
Now, Your Lordship, this particular, Your Lordship, suit has been filed.
Addition of party.
Is an addition of party application. The main crux of this application is that I have already, Your Lordship, purchased this property by way of a court decree by the Honorable Court. Now, this particular suit has been filed by the plaintiff in connection with a specific performance of an agreement in respect of the same property where I have not been impleaded as a party. And by virtue of a consent decree passed by the Honorable Court, Your Lordship, I have purchased the property, conveyance deed has been completed.
You are the defendant in that or you are the plaintiff?
I was plaintiff in that particular suit. If Your Lordship kindly sees once.
So it was the undefendant suit?
No, by consent decree, Your Lordship has been, by consent decree it has been purchased. Okay. Your Lordship kindly take page.
Your agreement is prior or later?
My agreement is prior, my lord.
No, Lordship, page 159 is my plaint, Your Lordship kindly sees.
159?
Page 159. Because his is oral agreement. And mine, Your Lordship, is an agreement, Your Lordship, which has been executed.
They are claiming for oral agreement?
Yes.
My suit is a specific performance on oral agreement, my lord.
Lordship, kindly take page 159.
Yes.
Page 159, Your Lordship, is my suit Jan Infrastructure Limited, Jan Infra Projects Limited. I am the nominee Rajashri. Lordship, kindly take page 174. Page 174 is a specific performance of an agreement dated 28 July 2008. Now, Lordship kindly sees page 189 onwards. The decree has already been passed. It starts from page 192. And if Your Lordship kindly sees his plaint, he is claiming, Your Lordship, the specific performance. Your Lordship,
if it's not been added, so your suit automatically been defeated.
And if your lordship sees order dated 26 March 2025, my lord, we have submitted. Your lordship has recorded our submission in paragraph 7 of the order.
26 March?
26 March 2025, your lordship.
Yes.
Counsel for the plaintiff submitted that he has no objection in allowing the application for the intervener without prejudice to the rights of the contents.
Not prejudice automatically because he has to file the return statement.
Exactly. From the very beginning, my lord, we have been saying that we do not
I'm allowing this.
GA2 may be allowed.
Only saying, my lord, kindly, after the formal order, my lord, next Friday, my lord, only
after this order, Your Lordship, nothing remains. Lordship, if I may be added as the party, Your Lordship, I
Today,
can
my lord, I'm a bit handicapped, my lord. That is why I'm saying, my lord.
Because GA2, Your Lordship, he himself has said, paragraph 7.
Yes.
There is also an application, my lord, filed by us for recording the death of the defendant number 3 and in consequent implement of the legal heirs, my lord.
That also may be allowed, your lordship. No problem.
May that be taken up next Friday, my
No,
lord? That
I am saying, your lordship, kindly allow that
my
application.
brief is not here, my lord.
I'm
That is the
giving
difficulty.
There's nothing in the
Sir,
application.
he is also leading me in this matter, my lord. He is also on his
Oh.
legs, my lord. Mr. Arif Ali is also leading me in this matter, my lord. Only next Friday, my lord.
As per the prayer made by the counsel for the plaintiff, case is adjourned. Let the matter appear on 1st August.
I'm grateful, your lordship.
First
My lord, 20, I appear for my lord the plaintiff in the suit. Lordship was hearing, my lord, the rejection of plaint application. My lord, Mr. Shobboshachi Chaudhary was leading me. He had made his submissions in response to their preliminary arguments. So they are in, my lord, rejoinder arguments. And just for a quick recapitulation, point that assent, deed of assent was not executed. Deed of assent was not executed, and therefore, my lord, the plaint should be rejected. This is their ground for rejection of the plaint. We have shown, my lord, from the, my lord, documents annexed to the plaint that it was referred to there also, my lord. Now they are to, my lord, rejoin in our.
Yes.
Lordship, I am to give a reply, but today, Lordship, the time may any other next week may it be fixed. I will conclude it. Another application is also pending, that is for extension of my time to file the written statement. It was prayed by my learned senior friend that may that be kept on record pending, and so once this application for rejection of plaint is heard, thereafter it will be decided.
Let him not face rejection. Let him, my lord, file the written statement.
Lordship, may it appear on the next day. I will make my submission.
Let the matter, as per the prayer made by the counsel for the defendant, let the matter appear on 1st August. Next.
The other side is not there.
Item?
No.
21. My lord, I am praying for an accommodation on behalf of.
ये अब क्या लिया? वही तो बोलता ये तो 20 है. Yes.
I'm praying for an accommodation on behalf of the counsel for the executor.
You all persons have got the matter assigned before this court and not doing the matter. Why?
But, my lord, he's out of town on a professional commitment.
Then I will go out of town.
My lord, kindly.
All the matter has been specially assigned before this court. The total 50 matters have been assigned.
Kindly grant.
But when the matter is called, my senior has gone to mainland, my senior has gone to foreign, my senior has gone here. What for you? This is the opportunity to argue the matter
I'm
before
not
the
briefed
court.
in this matter. I am unable to assist your lordship any further. My lord will kindly
today.
grant an accommodation.
Yes, call the passport matter. Okay.
I am appearing on behalf of plaintiff.
Yes.
My lord. Mr. Bagh was seen outside. Only 2 minutes.
Mr. Bagh is
Let the matter go out of the list.
No, my lord, fix it
Your
for
lordship
tomorrow.
only
Fix it for
given-
tomorrow.
Let the matter appear on 2nd September 2025.
It will be too late, my lord. It is very.
Yes, next.
2nd September.
My lord, in this matter, I am on behalf of the plaintiff petitioner, my lord. My lord, in this matter, my lord.
22.
pursuant to
22.
আমাদের কত?
Sharbani Banerjee.
22 is Sharbani
22.
Banerjee?
No, 22 is Jugal Kishore's.
Oh, my lord, I'm sorry, my lord.
Then ours is 25.
Ours is 25, my lord.
22 is Jugal Kishore. 22, who is appearing? Nobody.
No, my lord, I appear for the.
I
appear for the plaintiff, my lord.
Yes, what is the matter?
My lord, suit for my lord framing of the scheme for maintenance of the property, which is within the original site jurisdiction.
Lord, may I just say this? Prior to the last puja vacation,
There is an application pending, my lord, for appointment of the receiver. I believe in that application, the pleadings are complete.
Where is your pleading?
We have given the affidavit in opposition. It's already.
Our opposition, your reply.
Our reply
Yeah,
is ready.
GA1 is the receiver.
Yes,
GA1 is for
may I
receiver,
just-
my lord.
We have filed our affidavit in opposition to GA1.
I'm being
I
led
appeal for the defendant.
in this matter, my lord. My lord, your lordship may kindly keeps it next week. We will press that application.
My lord,
if I may take Mr. Gupta's leave for a second, my lord, the affidavit in opposition was, the direction was given to us at least 5 months prior. We had served within time. Because the business of the court did not permit the affidavit to be filed in court, it could not be filed in court. However, served. We are carrying the endorsement copy. We are yet to receive the reply to this affidavit. Lord, may I just refresh my lord's memory with respect to the matter?
No, please don't refresh. Lord, I am seeking that the matter may be taken up on the next day, Your Lordship. On the next Friday, we will do that
Lord,
matter.
then kindly
With
also records that they do not intend to file an affidavit.
No, I have
reply
not
to
said
the-
that. I have not.
They
Please
have
do not.
gotten more than 5 months time.
Today is a bad day for me. Please don't.
Lord, I have suffered the consequences of me being delayed in taking steps, Lord. My
But
lord,
we have not asked for cost, or we have not said anything which is
not been delayed.
Then please don't say that we are doing all that.
You are appearing for all defendants. Which
the respondent, the society.
All.
Yes.
Yes, and Lord, I appear
Appearing for
the
all.
Yes, my lord.
Yes, appearing for all.
I am led by Mr. Gupta on the
And you are for the
plaintiff. Lord.
Defendant has filed the affidavit in opposition in connection with GA1 of 2024 after serving the copy to the learned counsel for the plaintiff. Let the same be kept with the record. Counsel for the plaintiff prays for time to file affidavit in reply. Counsel for the defendant raised objection for extension of time to file reply on the ground that the affidavit in opposition is been served upon the plaintiff 5 months before, but till date the plaintiff has not filed affidavit in opposition. Considering the submission made by the counsel for the parties for the interest of justice, time to file affidavit in reply to the affidavit in opposition is extended for a further period of 1 week.
1 week.
Please the matter on.
Well, could we get a week's time from hearing date, a week's time from the date, because we need to see what is there and
On 8th August.
8th August.
I think
Yes.
5 months, but in January we have some. 28th of January.
7 months.
My lord, item number 25, my lord. Other side is there only a short prayer, my lord.
What short prayer?
My witness
May
was there.
I
He
request-
needs to be discharged and fixed for final argument.
Final argument.
My witness was cross-examined by my lord, Mr. Mitro, and
So we will not cross-examine
no,
further.
that is what they have chosen.
Item number
25.
25.
Any date, my lord, in September
date
for
be
cross-examination.
For
For
What is,
arguments.
give the file of 25. What is the last order?
last order was May 7th. my
You are
lord.
having the order.
Yes. My lord, with regard to certain documents, he has raised objection that was supposed to be heard. My lord, we do not want to produce that document to further because my lord, we want to.
There may be
whatever
the document may be beneficial for us.
No, my lord, we do not want to proceed with that document. Whatever question we have
The
asked,
cross-examination may be treated as closed. Cross can be treated as closed.
I was
Mitro is there.
raised by Mr. Ronnie. Closed and argument be fixed.
Counsel for the defendant, plaintiff.
Plaintiff, my
And
lord.
I am for defendant number 2.
Counsel for the plaintiff submitted they will not further cross-examine the defendant's witness. Defendant
number
number
2's
1.
witness.
Defendant number 2 witness. Accordingly, the evidence of the defendant's number 2 witness is closed. Counsel for the defendant number 2 submit that he will not adduce any further evidence.
No further.
What about the defendant number 1?
I appear for the
He has already laid evidence. Yes.
The counsel for the parties submit that evidence of all the parties have been completed and praying for fixing the matter for final argument. In view of the submission made by the counsel for the parties, let the matter appear on 11 September at 2 p.m. for argument.
On behalf of the plaintiff.
Complete they will start. No.
The defendant should start.
Defendant will start.
So that
The
is
defendant number 2 will start.
right.
The last witness.
So it is for me to start. Okay.
Yes, it is for Mr. Banerjee to start.
Last আমার witness গেছে তো।
Summons. I am seeking an interim order. Lordship can only fix it at a short date, Lordship, because it's
Next week.
next week, Lordship. Every Friday there's a 3:30. I'm missing my chance. Lordship will kindly schedule it. He gave.
I will change the date for the
I'm led by
non-commercial matters.
Lordship, I'm led by Mr. Dutt, his senior advocate, Lordship. Half an hour may be given, Lordship.
Item number 24.
24, Lordship.
Item number 24. No, लिखो मत. Manutosh, item number 24 na next week में. Yes.
My lord, may I mention a matter of the ordinary non-commercial side, my lord. The interim order is expiring today.
It is not listed.
It is not listed. My lord has
And
been
it is
pleased to
before
list
this
it on, my lord, it's a part-head matter. My lord has been pleased to list it on 19th of August, my lord. That's the next order. I'm mentioning upon notice.
So let the matter, who is appearing for the other side?
My lord, Mr.
Well,
Kakraya is
My lord,
online.
I seek crave leave to appear online, my lord. I am appearing for defendants.
I am extending the interim order till 19th August. Let the
My
matter
lord, may I pray
Yes,
for
yes,
one
my lord.
indulgence? My lord, 19th, my lord, I'm not in town, my lord, if it can be fixed on any other date.
19th August and automatic 22nd.
22nd, I'm grateful. My lord.
The counsel for the plaintiff mention the matter and submit that the interim order is till today and paid for extension of interim order. In view of the submission made by the counsel for the plaintiff, the interim order is extended till 22nd of August 2025 or until further order, whichever is earlier. Please the matter on 22nd August.
Deeply grateful.
Yeah, your lordships kindly leave to mention item 23.
83. Commercial.
Non-commercial, my lord.
Non-commercial 83.
23. 23.
My lord, I am appearing for the defendant in item 23.
Yes.
My lord, only one thing lordship sees, my lord, there are two applications which are there on board. One is my learned friend's application appearing for the plaintiff, that's GA1, where he has prayed for certain interim orders. There is already an existing interim order. I have filed GA2 of 2025 my lord, for rejection of plaint and for vacating the interim order that is in existence. My lord, it's a very short matter. Partition suit filed in respect of an immovable property which is at Park Circus. Essentially, it's a suit for land. This honorable court will not have territorial jurisdiction to enter in a suit for land where the immovable property is situated outside the original jurisdiction of this honorable court.
Yes. Counsel for the plaintiff submit that the interim order granted earlier is still today and prayed for extension of interim order. Counsel for the defendant submit that defendant has also filed an application being GA2 of 2025 for rejection of plaint.
Yes, my lord, rejection of plaint.
Rejection of plaint. Full stop. Considering the submission made by the counsel for the respective parties, कब एक डेट दे दो hearing के लिए. Pleadings completed.
My lord, so far as my learned friend's application is concerned, no directions have been given for filing an opposition.
File the affidavit.
I can do that. Yes.
In their application, they have not filed their reply, your lordship.
That we will file, my lord. My reply is ready.
That they have been taking time from last
to file
4 months,
affidavit
your
in
lordship.
opposition in connection with GA2
Getting the interim order extended from
and affidavit in reply in connection with GA1 of 2024. And full stop. Let affidavit in opposition in GA2 of 2025 as well as the reply in GA1 be filed within 2 weeks. Reply in GA2 of 2025 be filed within a week thereafter. 2 week on to 3 week okay, na? Let the matter appear on 22nd of August 2025.
Grateful, man.
What is extended
Grateful.
August 2025 or until further order, whichever.
Grateful.
Grateful.
Yes. Anything further?
Yes. Commercial matter, if I can mention today, otherwise I can come back on Monday and mention.
What?
Well, leave to file this application, that certain changes had been made in the cost title manually. So the department is now not accepting it. This has come from Bombay and it's notarized out there.
What?
Show my lord. That it was written correctly, my lord. Then, my lord, we were asked to change it. Now we are asked to go back to what was written by us in the cost title. Those words, my lord, ordinary original civil jurisdiction.
This is only
that only, my lord. Nothing else, my lord.
In the High Court at ordinary civil jurisdiction.
Yes, yes. It was written there originally. Then I was asked to cancel it, so I had cancelled it. Now again, I'm being told that go back to what was written. Your lordship will see what was written now was written earlier as well.
So this is correct one.
Now it's correct. Now it is correct.
इसी में लिखा and leave is granted to the plaintiff to correct the cost at and to file in the dip.
Great.
Lord, I am
no, yes.
Lord, mentioning item number 9, my lord.
Item number?
Item number 9, which has just, my lord, gone down. Your lordship, I request my lord to kindly.
Yes.
Lord, kindly, my lord.
No.
Your lordship, I'm sorry. My lord, just kindly hears me for a minute.
No, let go.
Your lordship,
So
kindly.
go.
Your lordship, kindly, just my lord, kindly, my lord, not pass that order, my lord. Kindly, my lord. It's a sincere request.
Where is the other side?
My lord, I am here. My lord, I am here. Hey, he's a junior member. Lordship will kindly pardon him, my lord. He must realize that he shouldn't do it. My lord.
Lord, let it be kept on the next week. My Lord, first we have contempt also fixed. Let it be tagged along.
Yes, anything? No.
What?